Yeah. Ma'am, kindly to mention item number 241 of your lordship's monthly list. This is an appeal against the order of an arbitrator under section 17 of the Arbitration Act. Lord, I had mentioned this matter before your lordship. Your lordship had directed me to come after some time. The matter pertains to a power plant where we are the respondent. The claim of the claimant is for specific performance and damages. During the arbitration, it is our assertion that they had given up their claim for specific performance. So we filed an application before the arbitrator seeking possession of the power plant. This application was under section 17. That application has been dismissed. So this is an appeal against that order. My difficulty is that the arbitration is on its final legs. Next week has been fixed sometime in December. Sometime has been December has been fixed for final hearings. It is my apprehension that the award may not be made CAV. So, I was humbly praying if your lordship could kindly hear that appeal out.
But what is the urgency in this?
The arbitration is in its final legs, we are in rejoinder, now in Sir rejoinder.
Right.
Rejoinder is complete in the final arguments. We are in Sir rejoinder.
So the arbitration will take care of all your issues also.
But possession, perhaps possession will have to be decided by your lordship, or else my appeal would be rendered infructuous. It's a section 37 appeal.
So your possession will also be decided by the arbitrator.
Possession would be
The
decided.
entire issue will be decided by the arbitrator.
Yes, my lord, but my application under section 17 has been rejected. My lord, I am seeking a statutory right of appeal. My lord, hence I was humbly praying if your lordship could kindly take it any day. But I had mentioned it before your lordship. Your lordship had directed me to come sometime later.
No need. Let the issues be decided. There's no urgency.
Kindly
No
reconsider them. It's item number 241 of your lordship's
No
monthly.
urgency, sir. Next.
Grateful,
Praying for the inclusion of the matter in the daily list.
What matter?
Section 14 application, lordship. I'm only praying for the inclusion. Section 14 application.
Inclusion.
Yes, in the daily list.
What is the urgency?
Urgency is that I have the cross examination is going on currently, and I have preferred this application under section 14.
Yes.
So that is the urgency, lordship. My cross examination is already going on, and it will be concluded in by the next date of the hearing.
So let it continue. What are the grounds?
Grounds, lordship. Grounds, lordship. I to you that the mentioning.
Nothing doing. Yes.
Your Lordship, may I be permitted to mention a matter wherein your Lordship was directed to file a written notes and submission on the previous occasion?
Provision is there are two matters, item 37 and 38 in the daily list, your lordship. Subject to your lordship's convenience, may take up any time today. We'll argue.
We'll see. We'll take it. Yes, call out the list.
For the award holder number 2, 3, 4 and 6, my lord, we have made payment the decretal amount yesterday by check, my lord. May I hand over the copy of the check was received on at around 4 o'clock. So we have deposited today in the morning, my lord.
Yes.
If your lordship keeps it on next Monday, by that time it will be cleared, then your lordship will record the satisfaction of the ticket. Yes, my lord.
Monday.
Monday, my lord. Monday. Monday, ठीक है?
Tuesday. Tuesday. We'll have it on Tuesday.
My lord, can it be on Thursday, Wednesday?
Not today, Wednesday.
Wednesday.
We'll see on Wednesday.
Wednesday week. Wednesday तो कल की तो हो जाएगा. Wednesday week. Wednesday
Next
week.
Next.
My application, my lord, under section 29A, my lord, praying for extension of the mandate. But the mandate, as per us, my lord, was already extended by the arbitrator for 6 months. That expired, my lord, on 15th of October 2025. Lord, during that time, Lord, we preferred an application on 29A before the commercial court. But Lord, thereafter, Lord, we came to learn about the judgment which says the court appointed the arbitrator has to be the court. Lord, thereafter we withdraw from there and Lord, we filed it here. Lord, that's why, Lord, there is some delay of 5 to 7 days probably. Else, Lord,
Delay doesn't really matter anymore as far as.
it's only an extension. Extension.
My lord, I am not opposing. Your lordship will kindly not record my consent.
Not record your consent. What should I record?
My lord, I
You're
oppose.
opposing?
Lord, yes.
See,
I
vehemently
record your opposition.
opposes.
Give me the grounds of opposition.
My lord, no grounds for opposition, but my lord cannot also give consent. Very well, your lordship records, my lord. Consent. But only thing, allegations may be, my lord.
There is no
Sure.
allegation.
Allegations, it's an extension of the tribunal takedown. Just give me the dates.
Yes.
When was the arbitrator appointed?
The appointment date is not December 21st, 2023.
Communication date.
Communication date, my lord, is January 3rd, 2024.
Pleadings completed on?
Pleadings completed, my lord, on 16th of April 2024.
All right.
And my lord,
The 6 months extension till?
Lord, on 3rd April 3, 2025.
And was expiring on?
Lord, that expired on October 15th, 2025.
All right.
Affidavit service that.
Takedown. The present application has been filed by the petitioner under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. Full stop. It is the case of the petitioner that this court, while order dated 21/12/2023, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 16/4/2024, comma, and with the consent of both sides, comma, the mandate of the arbitral tribunal was further extended for a period of 6 months. Full stop. The mandate subsequently expired on 15/10/2025, comma, whereafter the petitioner filed an application under Section 29A before the Commercial Court Rajarhat, being miscellaneous arbitration case number 48 of 2025. Learned counsel for the petitioner submits that, comma, during the pendency of the said application, comma, he became aware of the judgment dated 23/9/2025 passed by a coordinate bench of this court in APCOM 296 of 2025, comma, wherein it was held that when the appointment of the arbitrator is made by this court, comma, the jurisdiction to consider an application under Section 29A vests exclusively in this court. Full stop. In view thereof, comma, the petitioner withdrew miscellaneous case 48 of 2025 on 7/11/2025, comma, with liberty to file fresh before this court. Full stop. Learned counsel for the petitioner, Mr. Karmakar, further states that the pleadings are completed. Right?
Yes, pleadings
Pleadings
complete.
stands completed, comma, the parties have filed applications under, there's an
Section
application under
17.
17,
Section 17.
filed application under Section 17 and 31(6) of the Arbitration and Conciliation Act 1996, comma, the trial has not commenced, comma, and the application under Section 17 seeking interim relief is still pending adjudication. Full stop. Learned counsel for the respondent does not oppose the present application. Full stop. Upon consideration of the upon the consideration of the submission made by the parties and the material placed on record. Full stop. Comma. This court is satisfied that there has been no unwarranted or undue delay on part of the sole arbitrator in conducting the proceedings. Full stop. Having regard to the stage of the arbitration and in the interest of justice, the mandate of the sole arbitrator is extended further for a period of
1 year, my lord.
1 year from today. Full stop. Learned sole arbitrator is requested to make all reasonable endeavor to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the above observation, the present petition stands disposed of.
Obliged. Great.
I beg to appeal on behalf of the respondent. My lord, though I presume this is application for extension, but no copy has been served.
Copy has been served, my lord.
I have got the knowledge from an emails.
What do you want?
No, my lord, at least I should have the what is.
Some
He
copy
says-
has been served, but I can hand it over my copy also.
Give him the affidavit of service. He says the copy has been served, affidavit of service is here.
Daily. This video service as a daily.
I've got knowledge from the email
Yeah,
sent to
but
the learned.
What do you want tomorrow? What do you want?
No, my lord, if it can be taken up
My lord,
today,
they
then
are given consent in the 23.
I'm not opposing this application, my lord.
Oh.
What you want me to
Yes, the-
pass an order today? You want
The
to
order be passed. Order be passed. I want just a copy, my lord.
give a copy? Have you given a copy?
Yeah, I have to.
Give the dates. When was the arbitrator appointed?
My lord, arbitrator appointed on 9th October 2023. Page 21.
Readings completed on?
Was pleadings completed on 14th May 2024.
Extension
My lord, extension.
expired on?
My lord, it's originally expired on 10th May 2025. My lord, it was extended.
6 months. So that
for
will be
6
10
months,
11.
which ended on 10th November 2025. And it was extended on, my lord,
How
eight-
many hearings have been conducted?
my lord, 21 sittings. And the stage for evidence of the respondent.
Evidence of the
Evidence of the respondent.
All right. Irshad. First paragraph, same. This court appointed the arbitral tribunal by order dated 9/10/2023. Full stop. The pleadings were completed on 14/5/2024
I'm saying that,
with the consent of the parties, comma, the mandate was extended for 6 months. Full stop. For 6 months. Full stop. Now the mandate has expired on 10/11/2025. Full stop. It is stated by the learned counsel for the petitioner that the sole arbitrator has already conducted 21 hearings, and the matter is at the evidence stage. Full stop. In view thereof, the petitioner has filed the present application for extension of the mandate of the tribunal by 6 months. Full stop. Learned counsel for the respondent does not oppose the present petition. Full stop. Upon consideration of the submission of the parties and the material placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal in conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended further for a period of 6 months.
my lord, 1 year, my lord, because they took, my lord, evidence, chief has been completed on 8th July 2024 of the claimant.
1 year is too much.
My lord, 1 year they are taken for cross-examination. From the record, I will show.
The claimant
Push
is
it.
now
My
seeking.
lord, they take 1 year to cross-examine me. My lord, from the record, my lord, if your lordship come to page
You
28.
have asked for 6 months, sir. Look at your prayer, 6
Okay.
months. Your prayer for a period of 6 months. Full stop. It is क्या कहते हैं, the learned sole arbitrator is requested to ensure that the arbitral proceedings are concluded and the award is published within the extended time period.
Good.
Full stop. With the above observation, the present petition stands disposed.
Great.
With the
Let's make like
the
this
opposition.
affidavit of service taken under.
My lord, may I indicate, my lord, the affidavit in opposition I have served on him, but my lord, the affidavit is not in a position that I can hand it over to my lord. Reason being, it has not been affirmed by the deponent. Yesterday, at the time of affirmation, there was a problem with regard to the number. My lord, be that as it may, I am not on the affidavit. My lord, it is solely a point of law. I will be indicating from the dates that he has indicated and the minutes, and thereafter by two judgments, rather, my lord, three judgments of the Supreme Court, Delhi High Court, and Bombay High Court, how such delay has been taken care of by courts. My lord, if I may please, my lord.
Sure.
My lord, the 29A application, my lord, I appreciate that it is an application where extension may have been considered to be matter of course. The reason why I indicate may have been considered as matter of course is the reason that the at paragraph 15 of the Rohan Builders judgment, the Supreme Court has taken particular cognizance of section 29A subsection 5. My lord, I will be placing, rather, my lord, I would request my lord to consider the section 29A 4 and 5, because these are both these provisions are the basis on which this application has been filed. My lord, may I place the relevant provisions, my lord? If 29A 4 is taken, if the award is not,
Yes,
my lord, if the award is not made
that 5%.
within no, my lord, I'm not on the 5% part. I am on the first proviso, my lord, where
Read.
it says that if there is a delay for in reasonable reasons attributable to the arbitral tribunal, there will be reduction of fees. My lord, I believe both parties will not come up with this point, because the arbitrator is the only person who has acted the most diligently in the proceedings, and he has actually acted like a headmaster, put both of us to terms and done the proceedings. It is at the stage of final argument or
If
con-
that is the case, then it should be extended, because
it-
all that I
I
need to
have
see
no
is that the
argument on
arbitra-
my lord. Now kindly takes up 5. 5 is the extension of period referred to in subsection 4 may be on the application of any party and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. So, my lord, I am only on this, granted only for sufficient cause and on such terms and conditions as may be imposed by the court. Now, my lord, if my lord takes up my learned friend's application, my learned friend in his application has indicated that this particular arbitral reference had started on the basis of an
Yes.
order of appointment of 18th May 2022.
18th.
18th May 2022.
Yes.
My lord, therefore, my lord, the pleadings ought to have been completed by 17th of October, 17th of November 2022. But the parties, both parties have sought extensions. Section 17s were filed. My lord, ultimately, the rejoinder to the statement of defense and counterclaim was filed on 5th of June 2023. My lord, in terms of section 23(4), if I consider the rejoinder to the statement of defense as the statement of defense to the counterclaim, my lord, then this is the end of the pleadings. However, there was a further rejoinder filed by the respondent on 28th of August 2023. My lord, thereafter, an application was filed in September on 2nd September 2024. This application was disposed of, saying that no cause or no, it was expedition prematurely filed and there was no cause for granting such extension. This is on 2nd of September 2024, and in that order there was an observation that since 24th August the order was passed, till 23rd February 2025 the mandate is there. On that basis, my lord, on 6th there, and my lord, at this time parallelly two arbitral references were being heard. In respect of the first reference, on 6th of January 2025 the witness action is over. In respect of the second reference, on 12th of January 2025 the witness action of the claimant was over. The matter was fixed for on 3rd of March for the witness examination of the respondent's witness. And on 23rd February, the tribunal's mandate was expiring. So it was understood there was a 29A which was to be filed. My lord, the claimant does not come forward and file this 29A. So, my lord, after 12th of January, no sittings took place. My lord, from 23rd February, despite termination of the mandate and there being a sitting fixed on 3rd of March, 4th of March, 5th of March, 3 dates were fixed for completion of the witness action. The claimant does not come forward and file its statement. My lord, the claimant would come and say that there was a counterclaim and you ought to have come forward. But my counterclaim is mostly rejection of his claim
That doesn't matter.
and
That
some
doesn't
claim on
matter.
account of damages, and I did not pursue that, or I would not have pursued this, although the section provides for either party to come forward. I do not pursue this, but he comes forward only after 11 months, and from March, from 12th of February, there is no communication by the claimant. My lord, even if this is done, the claimant has to come forward in his petition and indicate any form of sufficient cause. My lord, if my lord takes my learned friend's petition, there is no mention as to what the cause was for not filing this application. My lord, he has narrated the entire facts that I have placed before my lord. He has narrated that till paragraph 24. And thereafter, my lord, there is pleadings with regard to jurisdiction. There is not one word with regard to the sufficient any cause which has restrained him from approaching this court or seeking necessary extensions. Now, with regard to the judgment and the law that is in force, my lord, may I hand over? Well, this is the Rohan Builders judgment, and my lord, this judgment was mainly on the issue whether the timeline within which the application was to be filed. But my lord, if my lord takes up paragraph 15, kindly takes up paragraph 15 of this judgment, my lord. In this judgment, 29A5, the provision that I'm arguing on, that is also taken and considered. Rohan Builders India Private Limited Supra highlights that an interpretation allowing an extension application post the expiry would encourage rogue litigant and render the timeline for making the award inconsequential. However, it is apposite to note that under section 29A5, the power of the court to extend the time is to be exercised only in case when there is sufficient cause for such extension. Such extension is not granted mechanically on filing of the application. The judicial discretion of the court in terms of the enactment acts as a deterrent against any party abusing the process of law or espousing a frivolous or vexatious application. Further, the court can impose terms and conditions while granting an extension. Delay, even on the part of the arbitral tribunal, is not countenanced. The first proviso to section 29A4 permits a fee reduction of up to 5% for each month of delay attributable to the arbitral tribunal. Well, I am not on the last sentence. I believe none of the parties will be, but my lord, I am only trying to indicate that it is not to be allowed as a matter of course. My lord, further, my lord kindly considers paragraph 17. My lord, may I place paragraph 17 as per second proviso to section 29A4, the mandate of the arbitral tribunal continues where an application under subsection 5 is pending. However, the application for extension of period of the arbitral tribunal is to be decided by the court in terms of subsection 5, and subsections 6 to 8 may be invoked. The power to extend time for making the award vests with the court and not with the arbitral tribunal. Therefore, the tribunal may not pronounce the award until the application under subsection 5 is sub judice before the court. My lord, this is more on the substitution aspect. Finally, my lord, paragraph 19 is what is material. In view of the discussions above, we hold that the application for extension of time period for passing an arbitral award under section 29A4 read with 29A5 is maintainable even after expiry of 12 months and the extended 6-month period. As such may be, as the case may be, the court, while adjudicating such extension applications, will be guided by the principles of sufficient cause and our observation in paragraph 15 of the judgment. So, my lord, paragraph 15 and that aspect 29A5 aspect of the previous decision is upheld. My lord, although with much difficulty, I have been able to pull out only a few cases where
लो मैं लिख लेता हूँ.
the court has dismissed an application under 29A. Well, may I please the first of such cases where the Delhi High Court has considered a 29A application, and my lord, may I indicate that this 29A application, the main premise was that this was filed after 17 months. My lord, if I may place from paragraph 8, because before that it is the factual enunciation. It is submitted on behalf of the respondent that since more than 17 months have lapsed from the date of the learned arbitrator's order, the petitioner has failed to provide any valid justification for approaching this court to request an extension of time for the conclusion of the arbitral proceedings. It is further submitted that this demonstrates the lackadaisical approach of the petitioner towards the arbitration proceedings. Thus, the instant application is an obvious instance of legal process abuse. My lord, thereafter, the entire statute has been reproduced. My lord, kindly comes to the last page, which is where paragraph 11.
Must have been challenged. What happened?
No, my lord, this has not been challenged. I did not find any further proceedings on this.
Yes.
My lord, the court finds it appropriate to reiterate the purpose of establishment of Section 29A of the Act of 1996 without a doubt is a commendable action. The purpose of this provision is expeditious disposal of arbitration proceedings, the establishment of a time restriction for the proclamation of an arbitral decision would dissuade the parties from seeking needless adjournments, which will ultimately favor the litigant who had opted for an alternative dispute process. And my lord, in view of this, application for delay in filing on account of the application for delay and the fact that this was at a belated stage, the petition was dismissed. My lord, apart from this, and this is similar to our facts because, my lord, even the 17-month period from the order included the 6 months of extension, and therefore there was a balance 11-month delay. Here, my lord, from February 23rd February till November, there is almost a similar 9-month delay, even if other factors are considered. And my lord,
And what about the counterclaim which was pending, where you have not taken any action? So there's no delay on your part.
my lord, insofar as my lord, my counterclaim, I'm not making any submission on that.
What do you mean you're not making any
Well, if-
submission? There's a
if the-
counterclaim which is already pending.
It is pending.
Whether you're making any submission or not, there's a delay on your part too.
Well, I have not taken steps.
So then,
So my lord will find this. If I'm to come up before my lord, what I have to do is I have to show sufficient cause for my delay. My lord, here there is a litigant who comes forward. He does not writes one line on the cause which has restrained him. I have to indicate my cause. And my lord, there is one more judgment of the Bombay High Court. This is a unreported judgment, my lord. My lord, kindly considers paragraph 5 of the judgment. Paragraph 5 and 6, the respondent has filed an application for closure of the proceedings, saying that they cannot, saying that they had not been concluded within 1 year. On this, the learned sole arbitrator made an application that since the time has not been extended, there being no application by the petitioners under.
before Rohan Builders, there's a different
ma'am.
ground for this.
My lord, but the ground for dismissal was
The
also
ground for dismissal is that, please read, sir, para 6.
my lord.
Mr. Bogle
Cannot-
cannot dispute the fact that petitioner was late in filing 29A petition. That is a ground for dismissal.
But my lord, there was some delay, which was
Ground for
My lord.
dismissal, sir, please.
so. My lord, these are the two judgments.
May I just briefly submit the legal position? First of all, the matter in Rohan Builders, the apex court, there are 3 bullet points. Firstly, 29A can be filed after the expiry of the mandate. The
That's a
second,
settled position.
that is a settled position. The second legal position is that there is no limitation prescribed to 29A, which has been discussed in the same judgment with my learned friend has
So
handed
what
over,
you
para
need to,
30.
Mr. Berry, what you need to overcome is that 11 months which he's talking about.
Yes.
That is the delay part which is saying that you have
Yes.
not taken any effective steps.
Admittedly, I'll concede to that effect. That first of all, the mandate expired on 24th of February 2020,
And give me those
25.
dates, yes. When did the mandate expire?
24th of February 2025. 23rd of February. I'm correcting myself. So the difficulty with the claimant to file is that there are certain logistical issues, and moreover, there is some financial restructuring with the company, due to which they were facing certain kind of financial hardships, due to which this application was not filed. Now, let's with regard to the third aspect, which has been discussed in Rohan Builders, is the sufficient cause. Now, that sufficient cause has been explained further in Ajay Protect judgment, which came immediately after Rohan Builder's judgment. Now, I'm just handing over the copy of the judgment. This is Ajay Protect. I'll just give you a copy. Now, I'll just read out para 9, 10, and 16. It is at page 7 minutes, para 9. The court in Rohan Builders has held that the application for extension can be filed even after the expiry of the period of subsection 1 and 3, even if subsection 4 provides for the termination of the tribunal's mandate on the expiry of the period. It recognizes that party autonomy to move an application before the court for extension. Thus, the termination of the mandate under provision is only conditional and non-filing of an application, extension application, and cannot be taken to mean that the mandate cannot be extended once it expires. The relevant portion is so and so. Nonetheless, I'll take out, with Miller's permission, para 10. Para 10 is the wording of 29A4 and the decision in Rohan Builders clearly answer the first issue in favor of the appellant. An application for extension can be filed either before or after the termination of the tribunal's mandate upon expiry of the statutory and extendable period. Nonetheless, with Miller's permission, I'll straight away come to para 16. Now, para 16, Millers will find at page 12, internal page 12, the meaning of sufficient cause for extending the time of making an award must take color from the underlying purpose of the arbitration process. The primary objective is rendering an arbitral award is to resolve disputes through the agreed dispute resolution mechanism as contracted by the parties. Therefore, sufficient cause should be interpreted in the context for facilitating effective dispute resolution. Nonetheless, insofar as the sufficient cause, there is one judgment by the Delhi High Court, wherein, because this is an objection which has been taken by my learned friend, that sufficient cause has not been pleaded or stated anywhere by the claimant. Now, let's para 8 of this judgment. May I read para 8 minutes? This.
Yeah, given a wrong judgment, I think. This judgment, Bombay High Court. He gave a
Oh,
wrong,
I'm so sorry.
gave a wrong
This is Delhi High Court. This judgment. I'm so sorry.
Yes.
May I read para 8? Insofar as the absence of any pleading of sufficient cause is concerned, there is no specific requirement in the 1996 Act of the pleading have to be made to that effect. The court has to be satisfied that there is a sufficient cause for extending the mandate of the tribunal. There is this is not a case that even as per the respondent, the prisoner has remiss in attending the proceedings. Nonetheless, in this particular matter, in both the matters, what I'll say is that the respondent has not participated from day one. He remained absent. He has taken adjournments one after the other. There are more than 8 occasions. The minutes I have already filed along with the petition. I'll just briefly highlight the dates. Because he wants to take out that I am the person who's making the trouble. Just a second. Let's may kindly have page 19. of the petition. Page 19 is the minutes. This is the second sitting on 28th of November 2022, the first para itself. The meeting was conducted today physically. None appeared for the respondent. As prayer for direction to file the counterclaim of the facts, and the counterclaim is within 6 months, together with the prayer of adjournment of the day's meeting was made at the last month. Mr. Berry has come all the way from Delhi. It is as such not possible to adjourn the meeting. Now, the very next meeting, which was held on 24th of February 2023, the first para itself, Milad. This is at page 21. May I read that, Milad?
What is the date of this order?
This is, Milad, 24th of February 2023. The first para itself, Milad, with Milad's permission, may I read that?
Yes.
No one appeared for the respondent in spite of the notice. It is already 6:45. The time scheduled was 5:30. The respondent is not likely to appear today. The defense cum counterclaim in both the matters have been received by the tribunal. Though the defense cum counterclaim in AP 237 or 22 has not been served upon the claimant, the meeting is conducted after the following direction, so and so. Now, let's immediately thereafter, if Milaz will have the fourth sitting, which is at page 23. This is 5th of June 2023. No one appeared for the respondent in spite of prior intimation. Now, I'll take out the minutes of the fifth sitting, which Milaz will find it at page 28. The first para itself, Milaz, page 28. May I read that, Milaz?
Yes.
The claimant has filed the affidavit of admission denial in both the matters and supplied the copies to the other side. The respondent has not till date filed the rejoinder. Though the time to do so has expired, Mr. Banerjee prayed for extension of time to file the rejoinder and the admission denial of documents in both the matters. Mr. Berry objected to the prayer for extension. According to him, the respondent has taken enough time and no further time should be granted. Mr. Banerjee shall file his rejoinder and admission denial in both the matters of 15th of July. Parties shall exchange amongst themselves the suggestive issues by 15th of July. Nonetheless, he says that I'll file it by 15th of July. Nonetheless, may kindly have the next sitting meeting, which is on page 30, 25th of July 2023. The opening para itself, Millards. The respondent, in spite of objection by Mr. Berry, learned advocate for the claimant, was granted extension to time to file the rejoinder admission denial by 15th of July. The respondent has, however, failed to do so. Mr. Banerjee, appearing for the respondent, submitted that the rejoinder admission denial are ready. If an opportunity is given to him, he may file it by tomorrow. Last opportunity is given to the respondent to file the rejoinder admission denial of documents by 31st of July. Again, he failed, Millards. If Millards will have the next minutes, which is at page 32, this is dated 24th of August 2023. May I read, Millards?
Yes, yes.
The time to file the rejoinder admission denial in both the matters expired on 31st of July 23. After several extension of time, the respondent was repeatedly directed to pay the initial fee of the arbitral tribunal. On the last occasion, the learned advocate for the respondent submitted that the payment shall be made by 31st of July. However, no such payment has been made till date. Today, after 6 p.m., Mr. Singh appeared for the respondent. He submitted rejoinder together with the admission denial in both the matters. Copy has been simultaneously supplied to Mr. Berry. The rejoinder admission denial belatedly submitted are accepted. Mr. Singh prayed for adjournment on the ground that his counsel is sick. So thereafter, what has happened here is, I'll just, with Miller's permission, hand over the minutes of the 10th meeting. So, the minutes are dated 22nd of January 2024. So again, on this day, he says that I'm unable to come. He prays for an adjournment. Being stationed at Calcutta, he says, I don't want to state the reason. So one after the other, he has taken adjournments. He has prevented himself for appearing in the arbitration proceedings, Millets. And moreover, Millets, another delay which was caused by him, he was asked to file his evidence, chief affidavit, by 25th of May 2024. This, Millets, this is captured in the minutes, which Mellors will find it at page 36. Sixth of May 2024. Millets, the very next page, Millets, at page 37. The second parameter, Mr. Chaudhary, learned advocate, submits that he shall file the affidavit containing the examination in chief of his witness by 21st of May 2024. Plus, this examination in chief was filed by him on 14th of November 2024. And this was filed by him on 14th of November. More than 450 pages, Millets. Still then I appeared before the learned arbitrator and I cross-examined the witness. This is the affidavit which was filed by him. And moreover, Millets, the issue over here is that both the matters, AP 236 and 237, are being jointly heard by the same arbitrator. The parties are the same, and moreover, only the project is different. So as per the oral directions, the moment the examination gets over in one matter, then the examination starts in the other matter. So the evidence is complete on behalf of both the parties. We'll find the minutes. The last minutes are at page 41 minutes. These are dated 6th of January 2025 minutes. I'm so sorry, Millets, I missed an important aspect. There is also a minutes of 18th sitting wherein the learned arbitrator already expressed that you complete all the things by February. Millets, may kindly have page 2nd of this minutes. The third parameters. The parties are reminded that as per the submission recorded earlier, the time to make time to make and publish the award shall expire in February 2025. The parties therefore are directed to conclude the matter by 10th of February 2025, and for that purpose, the meeting may be held from day to day between 10:30 a.m. and 4:30 p.m. The parties are further directed to recompute the fees of so and so. So, since the evidence got concluded on behalf of both the parties on 6th of January 25. Immediately thereafter, the evidence started in the other matter, AP 237. That was concluded on 12th of January. And the moment it was concluded, he was directed to file his evidence affidavit by 12th of January, which he failed to file. And the dates were fixed in March. Thereafter, the arbitrator had cancelled the sittings. Now he wants to say, he has stated in his objection that the evidence affidavit is ready from more than 11 months.
All right, take down.
May I just indicate 2-3 things?
Yes.
But the same factor, but the basis of which he has today shown 3 minutes before my lord, itself makes out a case that whatever sufficient pleadings was required was never made before the tribunal, was not made in this application. Apart from that, my lord, there are 2-3 things. Both the judgments that he has cited also imposes the same restriction with regard to 29A5, where he has to come and indicate sufficient cause. My lord, he has tried to prejudice this court by arguing the minutes prior or what has happened before the arbitral tribunal, all of which aspects have been condoned by the arbitrator as upon reasons being shown, or has been condoned, and thereafter the timelines have been calculated. My lord, important aspects also which has not been placed before my lord is the fact on 21st of January 2024, after he has shown minutes up to page 32, my lord, he does not show, my lord, page 33, where he comes up with a application for filing additional documents. After, I am very bad, but he comes up after 1.5 years to file additional documents. My lord, these, if he has to prejudice, there are even more than enough documents for us to prejudice during that period as well, because he has been traveling. We had always accommodated him, and even my lord, on 9th of July, it was on his insistence or indication, my lord. This is also annexed and has not been placed before my lord. That it was his understanding that the mandate of the tribunal expired, and he filed another application under 29A, which is why the affidavit of evidence could not be filed within that time. But every time, rather, even the previous occasion, when the affidavit of evidence was to be considered, my lord, there was an indication that the tribunal does not have jurisdiction. The matters were taken up, orders were passed, it came before court, 29A dismissed, and thereafter we went back and filed our affidavit of evidence. Even if we have been in the wrong, not one pleading to the effect that I am the one who has caused him not to file the application between February till date, is when his time period had expired. Till date he has not explained. Well, it is not that he cannot come before, and it is not that it has to be dismissed. The 29A5 indicates two things, my lord. One, sufficient cause. Two, put to certain conditions. My lord, this petitioner before my lord who has come up, if he had withdrawn or filed a subsequent pleadings to the effect indicating these the points, he may also have shown sufficient cause, then my lord could have allowed. I am not saying he is non-suited or does not have the right anymore, but the fact is his present application does not show sufficient cause, and that is to be considered by the court while allowing such an application, and it cannot be granted as a matter of course. So my lord, if such an application without any sufficient pleadings, well, it would
Take up.
set a wrong precedent. That is all, my lord.
Your conduct is very good. The present application has been filed under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the arbitral award. Full stop. This court-wide order dated 18/5/2022 appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 24/8/2023. Full stop. Thereafter, with the consent of both the sides, the mandate of the arbitral tribunal was extended by a further period of 6 months up to 23/2/2025. Full stop. The respondent's evidence has now concluded, and the final arguments are yet to commence. Full stop. In these circumstances, the petitioner has filed the present application seeking extension by 6 months for conclusion of the proceedings and publication of the award. Full stop. Learned counsel for the respondent opposes the present application. Full stop. He states that the petitioner has not shown sufficient cause for the delay in filing of the application. Full stop. He states that after the expiry of the mandate of the tribunal on 23/2/2025, the petitioner has taken more than 11 months to 9 months to file the present application. Full stop. He states that the petitioner in his pleading has failed to show sufficient cause and reason for the delay in filing of the application. Full stop. He has further relied on the judgment of Rohan Builders versus Berger Paints, reported as 2024 SCC Online SC 2494, as well as a judgment of the Honorable Delhi High Court in OMP miscellaneous 14 of 2019. Reported as 2023 SCC online Delhi 1276. Full stop. Do you want the other Bombay High Court also? Full stop. To buttress his argument that in case the petitioner fails to show sufficient cause in filing of the application, sufficient cause for the delay in filing of the application, the same shall not be automatically extended. Full stop. He has relied on paragraph 15 of the Supreme Court judgment. ये कोर्ट करना टिक टू टिक on such a ठीक है 52 which reads as follows. As relied on so and so. Full stop. Anything else? This is it.
My lord, 15 along with 19, my lord, because 19
15
after
along with paragraph 19. 19 भी कोर्ट का.
there is one more point, one more thing, my lord. I have served an affidavit in opposition. I have served on him, but it is ready, but it has not been affirmed. I can affirm it and file it if my lord grants me liberty. My lord may say that this was not considered during hearing on my submissions. Only for the record.
Learned counsel for the respondent further states that he has not been able to file his affidavit in opposition. So the same contains only the legal submissions which he has advanced before this court. Full stop. Learned counsel for the petitioner has drawn the attention of this court to the conduct of the respondent, wherein it has been observed by the tribunal in its various sittings dated 28/11/2022, what is the next one? The date is not clear.
It's 24th of
21.
February
24th of February
2023,
No, 2022. Page 21, give me the date.
page 22 minutes.
21. Give me the date of the sitting. The third sitting.
Third sitting is 24th of February 2023.
24th of February 2020. 2022.
2022, my lord.
Plus, there is a typographical error.
2023. Or
I mean,
5th of June 2023. Twentieth of June 2023. 5th of till 5th of June करना ठीक है, to show that the respondent has not been participating in the arbitral proceedings, and despite notice has been avoiding the arbitral proceedings. Full stop. He has further shown an order dated 20th June 2023 of the arbitral tribunal, wherein it has been noted that the respondent had taken several extensions for filing of the pleading, but had failed to do so, and the tribunal has expressed its anguish to the said fact. Full stop. The respondent had himself, the respondent had also filed his counterclaim, but had failed to pursue the same. It is further submitted by Mr. Berry that the respondent had also filed the counterclaim, but had not been diligent in pursuing the same. Full stop. This court has the learned counsel for the petitioner states that the delay in filing of the application was neither deliberate nor intentional. Full stop. According to him, two connected matters were proceeding simultaneously and evidence was being recorded in both. Full stop. Due to inadvertent oversight, the present application has been filed belatedly. Full stop. This court has heard the arguments advanced by the counsel for the parties and has perused the materials on record. The arbitral tribunal have substantially, it is noted that the arbitral tribunal has substantially progressed and the matter presently is at the stage of final arguments. Full stop. There has been no material to indicate any delay attributable to the learned arbitrator in conducting the proceedings. Full stop. The respondent, you are not saying that there is the respondent does not dispute that an extension is mandated to conclude the proceedings. Full stop.
Not the personal.
Though he has taken the ground of delay on part of the petitioner in not pursuing the application in time. Full stop. Be that it may, this court concurs with the respondent that the petitioner. This court concurs with the respondent that the petitioner ought to have approached this court with due promptitude so as to ensure the expeditious completion of the proceedings before the arbitral tribunal. Full stop. Nonetheless, such delay, by itself, cannot be permitted to defeat or extinguish the substantive rights of the parties. Full stop. Having regard to the substantial progress already made in the arbitration and in the interest of justice, the mandate of the arbitral tribunal is accordingly extended for a further period of 6 months from today. The arbitral tribunal is requested to make every endeavor to conclude the proceeding and publish the award within the extended time period. Full stop. With the above observation, the present petition is disposed of.
May I indicate one submission if in my reply, if that can be recorded, that arbitrator prior to 24th August has condoned my conduct. Only that is my submission, that 29A period has been computed after 24th August. If that can be recorded, my lord. And my lord, kindly grants me liberty. By the end of the first half, I'll file the affidavit, my lord. My lord, before my lord's officer.
You need to file it.
But it has been prepared.
I've already recorded.
Yeah, no, my lord, I will just file it because, my lord, without my lord's leave, my lord's officer will not.
You don't need to file it. Why do you want to file it?
I have served, my lord. That is the reason why.
So it will remain in the record.
How can you serve without
advance copy, my lord? My lord, the issue was
also should be stamped.
No, my lord, it has been ready. It has been prepared. It has to be signed before the affirmation authority. Oh, it is right now being affirmed, but it has to be affirmed before the authority. When we went yesterday, the issue was there are
This
two.
is your conduct. You have been appearing in this matter.
My lord, I will indicate.
In this very matter, this is the 4th time you are appearing or 3rd time you are appearing. Till date, you have not been able to get it affirmed. Even last week also you had appeared.
Yes, my lord. My lord,
So this is your conduct, and you are trying to say that the petitioner has been delaying it. Now, when you are using this court, and this is your conduct over here, Should I record all that?
I just want to indicate one thing. We tried to.
Or shall I record all that?
My lord, I'm not.
Look
trying
at
to
your
do-
conduct.
My lord, the reason is, my lord, the document which was submitted to us does not have the exact number. There are two applications. One is 236, one is 237. Now, my lord, we are confused, and the advance copy which was made
If
over.
you're confused, finish off the arbitration proceedings. Otherwise, you'll remain confused.
Plus, in the second matter, only the stage would change. In that matter, instead of final arguments, it will be
Respondent's
the
witness.
respondent's evidence.
Second वाला जो है ना, उसमें सिर्फ क्या लिखा है ना, at the stage of final argument. It's at the stage of recording of the respondent.
Evidence on behalf of the respondent.
Respondent.
That has been recorded at two places, my lord, at the beginning and also when my lord observes.
Highly grateful for this.
तो ठीक है डेट से सिर्फ वो जहाँ पे लिखा ना फाइनल
Same order.
Same.
4-5.
Much out.
Highly good.
My lord, I appear for the petitioner, my 29 application, my lord. Previously, 3 times extension taken. However, my lord, at the present moment, we don't want to deliberate much upon whose fault, who's not fault. Parties have filed their written notes of arguments. It is only due for publishing the award. A short extension should enable the arbitrator to pass the award. My lord, may kindly consider
Give the dates.
page number 7. Here we have given a chart of the dates, including till last extension.
Take down. The
Only one humble submission, Lordship, on behalf of the respondent, Lordship, because affidavits are not called for, my lord, all allegations in the application be deemed to be denied, your Lordship.
first paragraph same over the present application. This court-wide order dated 18/1/2022 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 22/7/2022. Full stop. With the consent of the parties, the mandate of the tribunal was thereafter extended by a further period of 6 months up to 21/2024. Full stop. Subsequently, this court-wide order dated 9/5/2024, 11/11/2024, and 19/5/2025 extended the mandate of the arbitral tribunal by 6 months on each occasion.
860.
Full stop. The mandate has now expired on 19/11, right?
Yes, my lord, but application filed before that.
19/11/2025. Full stop. Learned counsel for the petitioner submits that the final arguments have been concluded and the parties have been directed to file their
Written notes,
We have already filed.
which has
which has been filed.
has already been filed on
Lord, my lord, we filed it on 17th of November 2025.
when did you file it? Has been filed. Full stop. It is submitted now. It is submitted that only publication of the award remains, and therefore, an extension of how much time?
3 months.
months?
3 months.
3 months is sought to enable the arbitral tribunal to publish the award. Full stop. Learned counsel for the respondent does not oppose the present application. Full stop. This court notes that the arbitration commenced on 22nd July 2022 and the mandate has been extended on 4 occasions. Full stop. However, in view of the fact that the final arguments have concluded and now the pronouncement of the award remains, the mandate of the arbitral tribunal is extended further for a period of 3 months from today to enable the learned arbitrator to publish the award. Full stop. The learned sole arbitrator is requested to make every endeavor to publish the award within the extended time period. With the above observation, the present petition is disposed of. Application is disposed.
My lord, the notice of motion and affidavit of service.
Noted. Affidavit of service taken on record.
My lord, similar matter, but however, the dates are somewhat different. But between the
Dates are
textile
on-
parties, two contract. My lord, kindly
page?
refer page 8. Only the order date and pleading completion date is different. Otherwise, the extension dates are all,
Extension dates are same.
yes, extension dates are all same.
And the mandate expires on 19th November.
Yes, similar. 19th of November. Application filed on
First paragraph same hoga. This court-wide order dated 6/12/2021. 2021. Appointed the sole arbitrator. Sub same. Pleadings were completed on 16/11, same as the last one. 16/11. 2022. Same. Same. Pleadings completed on 16/11 and 6 months extension till 15/5/2024. 6 months extension uska next line ho. The pleadings were completed on 16/11/2024. यहाँ चेंज हो जाएगा 5/5/2024. 15/5/2024. 2024. इसके बाद subsequently this court by order dated 9/5. 11/11. 19/5 extended the mandate on each occasion. The mandate expired on 19/11. All right. हाँ उसके लास्ट पैराग्राफ में नहीं इसमें चेंज होगा. This court notes that the arbitration commenced on 6/12/2020. What is the date when it started? 6/12/2020. 1, right?
6/12/2021 order was passed. Pleadings were completed
6/12/2021.
16/11/2022. 1 year 16/11/2023. The affidavit of service and notice of motion. Thank you. Great.
Affidavit of service and notice of motion is taken.
Great.
My lord, this is my application, my lord, under section 29A for the purpose of extension of the mandate, just for the purpose of passing of the award, my lord. The mandate has expired on 19th of November 2025. The last extension, my lord, was by an order dated.
Give me the date of the appointment of the arbitrator.
My lord.
Arbitrator appointed on which date, sir?
My lord, arbitrator appointed by an order of 7th January 2020 by this honorable court.
All right. Pleadings completed on?
My lord, pleadings completed on 7th of November 2021.
All right. Mandate extended?
My lord, mandate extended. My lord, the first extension of 6 months.
The first extension was the 3rd September.
3rd September
2024. And
till 31st of August?
Till 21st of August. There.
31st of August?
31st of August, my lord.
And then after that?
My lord, the next extension was on 29th of April 2025. That was the last extension by this honorable court.
All right. How many extensions you have taken? 2?
Only 2.
My lord, 2 extensions, my lord.
2 extensions?
2 extensions.
8 months, 6 months?
6 months, 8 months. 8 months, 6 months.
Award reserved on?
Award has been reserved on 23rd of May, 2025. 23rd of May. The last minutes is at page 93, my lord, of the petition. My lord, to be very candid, my lord, the only I could not plead it in so many words. The learned arbitrator had some health issues in between. So that's why
Eye problem, sir. Eye problem.
eye problem. So I had added a line.
All right, all right.
I have prayed for 2 months' time, my lord, subject to
The first to same है present application है. This court by order dated 7/1/2020, appointed the sole arbitrator to adjudicate the dispute between the party. Full stop. The pleading completed on 7/11/2021 with the consent of the parties. The mandate of the tribunal was further extended. Was thereafter extended by a further period of 6 months up to 31/8/2023. Full stop. Subsequently, this court by orders dated 3/9/2024 and 29/4/2025 extended the mandate of the arbitral tribunal by 8 months and 6 months respectively. Full stop. The mandate has now expired on. When did the mandate expire?
Mandate expired on 22nd November. With a project from the 29th from the
no 6 days we will lose. So it is 19th of November. Actual calculation.
When is it?
My lord, 19th of November
19th 2025. Full stop.
actual
Learned counsel for the petitioner submits that the learned sole arbitrator, after concluding the proceedings, reserve the award on 24/4/2025. However, due to his ill health, could not publish the same within the extended time period. Full stop. In view thereof, learned counsel for the petitioner prays for a further extension of 2 months for publication of the award. Full stop. Learned counsel for the respondent does not oppose the present application and states that the arbitrator was suffering from health issues. Full stop. This court notes that the arbitration commenced on 7/1/2020 and the mandate has been extended on 3 occasions, on 3 earlier occasions. Full stop. However, in view of the fact that the final arguments have concluded and only the pronouncement of the award remains, the mandate of the arbitral tribunal is extended further for a period of 2 months from today to enable the sole arbitrator to publish the award. Full stop. The learned sole arbitrator is requested to make all endeavors to publish the award within the extended time period. Full stop. With the above observation, the present application is disposed of.
Deeply obliged.
Section 29A application. In this matter, my lord, after the arbitration proceedings were initiated, respondent number 2 and 3, 2 and 3 came up and said that they are gone under, my lord, CIRP. So, my lord, the moratorium, my lord, sets in over them, and accordingly, the arbitral tribunal, my lord, had, my lord, kept in abeyance as far as, my lord, the proceedings against them are concerned, because we cannot. As far as one is concerned, they never appeared. But, my lord, we have served on them. We have received the section 29 application. So, my lord, this needs to be extended, my lord. The service is on record, my lord. I have served on respondent number 1, my lord. 2 and 3 also I have served, but then, my lord, they are not. I cannot proceed. There cannot be any order against them as such, my lord. But I have served on all of them. My lord, the arbitrator was appointed, my lord, by this honorable court on 18th of September 2024, my lord. Page 9, my lord, lordship will find the order, my lord. And the first sitting, my lord, is on, my lord, 7th of October 2024. And my lord, the statement of claim was filed on, my lord, 13th of November 2024, my lord.
When the pleadings were completed?
Pleadings was complete because, my lord, statement of defense, they have not appeared, my lord. So he has calculated from that date itself, my lord.
And
Now, my lord, it expired on, my lord, 12th of November 2025. Sorry, 12th of November 2025. Yes, my lord. And this was filed, my lord, prior to that. On stage, yes. And we are at the stage of argument, my lord.
Take down. Same first paragraph हो जाएगा. This court-wide order dated 18 September 2024, appointed sole arbitrator to adjudicate the dispute between the party. Full stop. The respondents, none had appeared.
No. And 3 appeared. They came and filed an application stating that it's no longer maintainable against them, my lord. One never
Petition
appeared.
states that the respondent number 2 and 3 had appeared before the court and states that then the company has gone into insolvency.
Yes, my lord.
That the company
2 and 3, my lord.
gone into insolvency and full stop. None appeared on behalf of the respondent before the arbitral proceedings. Full stop. The mandate of the arbitral tribunal expired on 12/11/2025. It is stated by the learned counsel for the petition that the matter is now at the stage of final argument, and he seeks extension of the mandate of the arbitral tribunal. Upon consideration of the submission, the materials on record, this court is satisfied that there has been no undue or unwarranted delay on part of the tribunal in arbitral tribunal in conducting the proceedings. Accordingly, the mandate of the arbitral tribunal is extended further for a period of 2 months. 6 months.
So 6 months because argument and award. So, my lord, I'm saying 6 months. To be, my lord, I have no issues, but I'm only saying, my lord, to be on the 6 months.
From today. The arbitral tribunal is requested to ensure that the arbitral
2 and 3 chade diye
is concluded and the award is published within the extended time period. With the above observation, the petition stands. Affidavit of service is taken.
It was service complete. Lord, here also, my lord, 2 and 3, my lord, has been, my lord, stayed against them because of the NCLT proceedings. 1, my lord, has never appeared. Here, my lord, the order of appointment was 3rd of September 2024, my lord. The first, my lord, sitting was 7th of October 2024. And, my lord, statement of claim was filed on 16th of November 2024. Here, since, my lord, the order, my lord, by which they were, my lord, proceedings against 2 and 3 was stayed was 19th of December 2024. And then, my lord, since 1 was not appearing even after service, so, my lord, the proceedings was made ex parte on 23rd of April 2025. And, my lord, the mandate expired on 15th of November 2025. Here, my lord, at least, my lord, I have served still, my lord, on the respondent number 1 also. Because, my lord, and 2 and 3 also. This also argument, my lord, at the stage of argument.
This court-wide order dated 3/9/2024 appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The respondent number 2 and 3 were proceeded. All the respondents were proceeded ex parte. The respondent number 2 and 3 had gone into insolvency, and the arbitrator, by its order dated 19/12/2024. Where is the order page?
My lord, that order, my lord, is at Page 19. Well, gives me one moment. Page 19. Oh, state creditor. Page 18, it starts, my lord. And the operative portion, my lord, is at
In view.
21 third paragraph.
क्या लिखा है?
X particular article.
22/1/2025 had noted. 22/1/2025 noted that since respond number 2 and 3
X party কোথায় বললো?
have gone into insolvency, the proceedings against them were stayed.
সেটা বলো, এটা কেন দেখাচ্ছ?
Full stop. The arbitral tribunal proceeded ex parte against respond number 1 by authority dated 23/4/2025. The mandate of the tribunal expired on 15/11/2025. Full stop. Learned counsel for the petitioner states that the matter is now at the stage of final argument, and petitioner prays for extension of the mandate of the arbitral tribunal by appropriate full stop.
Batchmate.
By appropriate time.
কোথায় আমি কোথায়?
Upon consideration of the submissions and the material placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal in conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is hereby extended for a period of 6 months from today. The arbitral tribunal is requested to ensure that the proceedings.
Grateful, madam.
In my application of section 29, I am praying for 1 week extension. Let my colleague argue it with 29 extension letter.
My lord, my application under section 29A. If my lord kindly takes the list of dates, the learned arbitrator was appointed through section 11 proceedings, my lord. That was on 13th April 2023. The learned arbitral tribunal entered into reference on 2nd May. Pleadings were complete, my lord, on 12th June 23. And the first 6 months extension was granted in the sitting held on 15th May 2024. That expired, my lord, on 11th December 2024. And in the meantime, we applied for under section 29A. That was on 20th November. An order was passed extending the time for 1 year. That 1 year period, my lord, expired on 21st November. This application was filed on 20th November, my lord. And my lord, since the last extension, 15 sittings have been held from 27th sitting to 41st sitting. And my lord, we are at the stage where claimants' witnesses have been examined and cross-examined. Respondent second witness is being examined right now, cross-examined right now. Thereafter, my lord, hearing and then passing of award. So we are praying for 8 months extension or 6 months extension, my lord.
Whatever lordship gives us, it will take 1 day for cross-examination and pleadings, will my argument be over in 2 days. The eviction proceeding.
6 months, I think, should be enough.
8 months lordship gives me on the safer side. I don't want to come back again. Justice Chakraborty is also not with us. Grateful.
The first paragraph same hoga. This court by order dated 13/4/2023 appointed the sole arbitrator to adjudicate the dispute between the parties. The pleadings were completed on 12/6/2023, with the consent of the parties, the mandate of the arbitral tribunal was thereafter extended by a further period of 6 months up to 11/12/2024, full stop. Thereafter, this court-wide order dated 20/11/2024 extended the mandate of the tribunal by 1 year from the date of communication of the said order, full stop. Hence, the said timeline also expired on 21/11, right?
Yes, my lord.
21/11/2025, full stop. Learned counsel for the petitioner submits that there has been 41
There have been total of 41 sittings.
41 hearings, and the matter is at the stage of conclusion of evidence.
Yes, my lord.
Full stop. In view thereof, the learned counsel for the petitioner is praying for extension of 8 months.
Yes, ma'am.
For 8 months, extension of 8 months of the mandate for conclusion of the proceedings before the arbitral tribunal. Full stop. Upon consideration of the submission that the material placed on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitral tribunal arbitrator in proceeding with in conducting the proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended further for a period of 8 months from today.
I'm grateful, ma'am.
Full stop. The arbitral tribunal is requested to ensure that the arbitral proceedings are concluded and the award is published within the said extended time period. 6 months should be good enough.
My lord.
My lord, the examination is not yet complete. I guess we need 8 months, my lord.
We have already taken 1 year extension.
No, the
6 months should
arguments.
be good enough. Finish it off 6 months.
My lord, let the affidavit of service be taken up.
Affidavit of service taken on record. इसमें एक line लिखवा देना. The learned counsel for the respondent does not oppose the present application.
Great.
Let them finish it off.
Lordship, this is my section 29A application for the extension of the mandate of the arbitrator. Lordship, this is the second extension being taken. Lordship, this is a chart of the list of dates for your reference.
Lord, I'm appearing for the respondent.
Lordship, the appointment was through a section 11 on December 22, 2022. Lordship, the pleadings were completed on 18th of May 2023. Lordship, thereafter the examination and the cross-examination of the CW1 claimant's witness number 1 was continuing. They had given an additional evidence also. Thereafter, Lordship, the expiry of 6 months happened on 18th November 2024. The extension of the mandate to the order, the first extension was on 18th November 2024, Lordship, which is at page 27 of my petition, which states that the extension will be 1 year from the date of communication of the order to the arbitral tribunal. Lordship, the order was communicated on the next sitting, that is on 25th November 2024. Lordship, the 1 year completes today, that is 25th November 2025. Lordship, the witness action has been completed. We are at the stage when the respondents will start their arguments.
Take that. First paragraph of same. This court-wide order dated 22. This is December, right?
Yes.
22/12.
22nd December
22nd December 2022, appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 18th, right?
18th May
2023. Full stop. With the consent of the parties, the mandate of the tribunal was thereafter extended by a further period of 6 months up to 18th
November 2024.
18th November 2024, full stop. Subsequently, this court-wide order dated 18th November 2024 extended the mandate by a further period of 1 year from the date of communication of the said order, full stop. Hence, as per the said order, the mandate expired on 25/11.
25th November
25th
2025.
11 2025. Full stop. Learned counsel for the petitioner submits that the arbitral tribunal has conducted 21 hearings and that there has been no 21 hearings. Now it is at the stage of
Arguments will start. Comment.
the 21 hearings and the evidence has already concluded. Full stop. She states that it is at the stage of final arguments. Full stop. Learned counsel for the respondent states that she has no objection to the present application. Full stop. Upon consideration of the submission and the materials on record, this court is satisfied that there has been no undue or unwarranted delay on part of the arbitrator in conducting its proceedings. Full stop. Accordingly, the mandate of the arbitral tribunal is extended for a further period of how much time?
Lordship, 8 months.
Why 8 months? Final argument, publication of about 6 months. 6 months from today. The arbitral tribunal is requested to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. With the above observation, the present application is disposed of. Yes.
My lord, I am for the petitioner. My section 9. My lord, Mr. Mukherjee was addressing your lordship.
Yes, there were some talks.
Yes, my lord.
Yes.
My learned friend was to take instructions whether they
Okay,
want
I've
to.
taken instruction. My client is willing to get the residual work done. So we can sit, the parties can sit and we can
Very well.
adjourn the matter for 3 weeks.
That this matter be adjourned to.
My lord, grants us 3
Learned
weeks. my
counsel
lord,
for the
you should
parties state that they are exploring the possibilities of an amicable settlement. Both the parties pray for an adjournment. Let this matter stand over for another 2 weeks.
2 weeks, my lord. 2 weeks.
2 weeks. 2 weeks.
Great.
Lordship,
Yes.
actually, today's morning, my client actually received this application
Today morning. Yes.
and give some times a period for 7 days to appropriate instruction from my client.
My lord, this was, may I file my affidavit of service?
Ronnie, you're giving the application late.
Sorry, my lord.
The application has been received just yesterday or today morning, she's saying.
Today's morning, my
Today
client
morning.
as per my client's instruction.
My lord, I'm just personally checking, my lord, the affidavit of service. My lord, it was delivered yesterday at 3 p.m. My lord, may I?
Yes. Maybe they have received the instruction today in the morning.
My lord, they have taken away my vehicle.
Yes.
I'm agreeable to depositing the 2 months arrears and my lord for the loan to revive. But they've taken away the my lord vehicle with goons without my lord any notice, without any prior intimation. The agreement, my lord, makes it an obligation upon them to give me a 7 days notice if there's a default and give me a chance to rectify the default within 7 days. Nothing done. They intercept my truck while it was in course of business at the Bombay Calcutta highway and my lord, they take away the truck.
Yes, madam.
Lordship, kindly grant the time for 2 weeks for filing this wakalatnama.
2 weeks?
2 weeks, you'll dispose of the truck.
Lord, let there be an order in the meantime that they won't, or let my friend undertake that she won't sell the truck. That's also enough. If my friend undertakes, I have no.
The point.
They may take time, my lord, no difficulty. But if my truck goes, my lord, it's an irreparable loss.
Yes, tell me.
To grant us time period for 1 week at least, my lord.
My lord, as long as my friend wishes to take maybe 1 week, 10 days, at least for that period, my lord, let there, my lord, be an order. And my lord, we'll come back before your lordship.
Take down. The petitioner has preferred the present application under Section 9 of the Arbitration and Conciliation Act 1996, seeking an order of restraint
Lordship, kindly give direct them serve a copy of this application.
You don't have a copy of the application?
No, I have no copy. Actually, my clients have the copy.
So you get it from your
Give a
client?
copy, you come back tomorrow, then let them take instruction. I don't want to pass an order.
Very good.
You come back tomorrow
Alright.
with the instruction that you will not alienate or sell the property, the truck. Give a copy of we'll have it tomorrow.
And my lord, also the fact that I'm willing to, my lord, give them the arrears, 2 months arrears.
Let them come. If they have already done it, she doesn't have instruction also. You know how they function. You come back with the instruction tomorrow.
Yes, my shop.
My lord, then would your lordship consider making it day after?
Day after.
Subject to court's convenience.
Day after. I'm not recording any order. Day after. Not today, day after.
And it retains its position on the list, my lord. Grateful.
This is my Section 9 application, Lordship, appearing for the first time. The service is already on record. Lordship, we have served and they have received it. Lordship, I'm praying for that injunction on the bank account. Lordship, I can serve again and come. This is my.
Serve again. Bank account injunction, I don't know. Take down. The petitioner has filed the present application under section 9 of the Arbitration and Conciliation Act, seeking a direction upon the respondent to furnish adequate security for the outstanding dues payable to the petitioner. Full stop. In the event the respondent fails to furnish such security, the petitioner seeks an order of attachment of the respondent's bank account as detailed in Annexure E. Annexure E, right?
Annexure E.
Annexure E. Full stop. It is the case of the petitioner that loan amount is 15 lakhs, right?
15 lakhs.
It is the case of the petitioner that a credit facility of rupees 15 lakhs was extended to the respondent while pursuant to a loan agreement dated 21st August 2024, repayable in 36 months. In 36 months, along with interest at the rate of, what is the interest?
Lordship, at the rate of, Lordship, 19.5%.
19.5% per annum. Full stop. The petitioner states that the respondent allegedly defaulted from the seventh installment onwards. Full stop. Consequently, the petitioner terminated the loan agreement. When did he terminate?
Lordship, 18th April 2025.
By loan recall notice dated 18th April 2025 and demanded a sum of rupees 14,17,728.50. Full stop. As the respondent failed to make payment, the petitioner referred the dispute to the online dispute resolution platform on 28/4/2025, where an arbitrator was appointed on 30th April 2025. Full stop. However, the respondent objected to the said appointment, leading to the arbitrator recusing himself while letter dated 24th September 2025. The petitioner submits that steps have been taken for appointment of arbitrator, for appointment of another arbitrator. Full stop. The petitioner submits. Meanwhile, the amount has accumulated to rupees 15,57,105.84. Full stop. Hence, the present petition has been filed seeking direction against the respondent to furnish adequate security for the said outstanding amount, failing which the bank account mentioned in Annexure E shall be attached. learned counsel for the petitioner refers to clause 8 of the loan agreement dated 21/8/2024, which contains the arbitration clause, full stop. It is further submitted that the entire transaction took place within the territorial jurisdiction of this court, comma, and thereafter, and therefore this court is competent to entertain the present petition, full stop. None appears. Learned counsel for the petitioner states that though affidavit of service is taken on record, learned counsel for the petitioner states that she will again serve the respondent that this matter be listed after 2 weeks. 2 weeks or 4 weeks when you, after 4 weeks. ये सारे हुआ practice. हाँ ठीक एक ही है रिपोर्ट है I'll come back.
Application appearing for the first time, Lordship served on the respondents. Similar prayer I am asking.
Just give the dates.
That's there. The chart is there.
ये same change. Yes. Which one is your item?
Lordship is item 37 and 38.
Who's there on the other side?
Mr. Shayan Gupta is on the other side. I can inform him if your lordship
दो
is
बजे क्या है? कुछ नहीं है. Normal. ये 37, 38 ले सकते हैं. हाँ. We will take your matter then at 2.
Great.
For
Great.
the other side.
I will inform.
Huh?
I will inform.
Yeah. Hmm. You're coming from outside?
Yes, sir. I have traveled
Where are you
from
coming from?
Delhi.
We have not started the hearing in this.
Yes, your lordship, you have heard me substantially. I'm for the respondent. My objections, your lordships have heard.
All
It
right,
is
you
just
come
for
at
the-
2 o'clock. Will
Grateful, lordship. I'll inform Mr. Gupta.
So this is my application under section 14, read with section 15, my lord. For my lord, removal of an arbitrator and substitution of the same, my lord, by another arbitrator.
And I'm objecting to the maintainability of this application.
Maintainability on the ground?
My lord, there is no ground under the 7th schedule. Unless
So
the
this is-
arbitrator falls under the 7th schedule, there is no 14.
Section 14 application.
Section 14, read with section 15, my lord. My lord, this was an arbitrator who was appointed by this honorable court, my lord. Page bolo na. Kindly comes to my lord page 16, my lord. What the paginity kora nahi. Oh, এটা নতুন কায়দা তোমাদের। My lord, by an order of 22nd February 2022, mother, the paginations are at the bottom of the page, my lord. I'm sorry. The arbitrator was appointed by this honorable court. কোথায়? নাম কই? Oh. And my lord, he had entered appearance, my lord, before, my lord, anything cropped up, my lord. 8 February. Kindly comes to page 18, my lord. That's the first minute. That is the, my lord, first letter issued by the learned arbitrator, my lord, on 24th of March 2022.
18.
Page 18 is the letter, my lord, by which the learned arbitrator had informed us of, my lord, the first sitting.
Yes.
Now, my lord, kindly comes to the first sitting. This is very important, which is of 23rd of April 2022. My lord, kindly takes the first paragraph pursuant to a notice dated page 19, my lord.
You said 18.
The next page, my lord. I'm sorry, my lord.
No.
That's the first meeting, my lord. At the top, lordship will find 23rd April 2022 first sitting.
Yes, yes.
Paragraph, my lord, first paragraph. Pursuant to a notice dated 21st April 2022, I convene the meeting for the purpose of issuing necessary directions in the initial arbitral reference. Prior to issuing such directions, it has been disclosed to the council appearing on behalf of both the claimant and the respondent that I have represented Shrey Equipment Finance Limited in some matters, as well as appeared against Shrey Equipment Finance Limited in various matters before various fora. So, my lord, this is pre-arbitration. Kindly, my lord, sees his statement that he has appeared for Shrey and against Shrey. Then, my lord, the next paragraph. At present, I do not have any engagement in any matter of Shrey Equipment Finance Limited or its sister concern and or subsidiary. Therefore, my lord, the disclosure at paragraph 2 is that on the date of the first sitting, he does not have, my lord, any engagement with any of the parties, my lord, including the claimant. Now, my lord, kindly sees the next paragraph. and my lord leaves the first two lines. The sentence starts, my lord, I am presently. Lordship has got it, my lord. I am presently engaged by SMS Limited in an arbitration against Shrey Equipment Finance Limited. Apart from these present engagements, this is very important, I do not have any engagement either on behalf of Shrey or against Shrey. So the disclosure is very clear that on this date, except for an arbitration proceeding against Shrey, he does not have any other, my lord, engagements against the claimant or for the claimant. That's his disclosure. And my lord, accordingly, we had proceeded saying that that is all right, since my lord, he is only engaged in an arbitration proceeding against Shrey. We had no objections. Now, my lord, we proceeded against this, my lord, in the arbitration proceedings. 16 sittings were held, and my lord, we come to know, my lord, that during the arbitration proceedings, my lord, the arbitrator is taking up matters in court against the claimant. Now, my lord, we sought for a disclosure. Now, my lord, kindly sees that disclosure at page 22, which is very startling, my lord. Kindly comes to page 22. That's, my lord, a letter of 8th February 2025. Now, in the meantime, I must also say, my lord, since we were in August, when we were not aware, my lord, of this engagements further, we had filed a 29A because his mandate was expiring, and that 29A was extended. Now, my lord, kindly sees apropos that, my lord, this disclosure of 8th February 2025. I was appointed as an arbitrator by an order dated 22nd February 2022, wherein the parties consented to such appointment and also undertook not to raise any objection to such appointment of the Honorable Court. Subject to any objection, the parties may be entitled to raise in the future. So, my lord, he also, my lord, records that if there is an objection, we can raise in the future. At the sitting held on 20th December 2024, so my lord, this is post the extension under 29A, admittedly, the advocate on behalf of Shrey raised a concern that their clients may not be comfortable in proceeding with the arbitration before me as the arbitrator, in as much as I have been engaged as a counsel in a proceeding against Shrey before the Honorable High Court at Calcutta. However, it is surprising to note that such objection is being raised at this belated stage post the extension granted by the Honorable High Court at Calcutta to the mandate of the arbitrator and to make and publish the award on 7th November 2024. This is natural, my lord, because by that time we had not asked for a my lord, a further disclosures. So that was in August. Then, my lord, the arbitrator is not under any obligation to issue any clarification. I'll show, my lord, in the act it is so. So keep the independency, my lord. However, it is deemed fit to bring to the notice of the parties that I have been engaged. I have been engaged, my lord. So this is after, as a counsel in 3 separate matters against Shrey, the claimant. And then, my lord, the disclosures are given that post during the proceedings being held, he has been constantly appearing in almost 4 matters. He's been briefed and he's taken the brief and he's appearing against them in the court, my lord. Now, my lord, kindly sees apropos this, we made an application, my lord, which is, my lord, starts from page 24. Final order dismiss করেছে. And, my lord, after hearing both the parties, my lord, the arbitral tribunal, my lord, at page 63 refuses to, my lord, recuse himself.
So the ground on which, just see page 23 also, the last paragraph.
Page 23, my lord.
There's a
Yes.
defense being given by him.
Yes, my lord. It is also pertinent to state that I have appeared in the aforesaid matters prior to the application being allowed under section 29A. Possible, my lord, it was not aware. Yes, possible, my lord. I'm not saying, my lord. It is, my lord, when I come to know, I'll make a request for disclosure. Now, my lord, disclosure is to be made by the arbitrator. My request is not required. I'll show that from the law itself. Hence, it is surprising that such a contention is sought to be raised now it is also essential that I keep it on record that I have appeared in several matters for the claimant, that is Sri, as well as before several of it in the past. To that we agreed. That is why, my lord, I showed the first minute that prior to the appointment, if you have appeared, we had no issues whatsoever. But during the pendency, you cannot take any fresh matters against me. Now, my lord, kindly sees, my lord, page 63 is the order by which, my lord, my application under 12 read with 13 was rejected. My lord, the operative part kindly comes to, my lord, paragraph 20 at page, my lord, 68.
Page
68, my lord.
starts from.
My lord, it starts from. It starts now. Order to start 63. It starts from, my lord. The operative portion, my lord, starts from page 67, paragraph 18. My lord, may I read?
Yes.
The claimant has long been aware of the sole arbitrator appearing matters as a counsel against the claimant since 2021. No issues, my lord, that's recorded. Orders to such effect would reflect the same. The sole arbitrator has appeared in matters against the claimant after he had entered the present reference. So, my lord, this he makes a admission. The claimant did not raise any objection or did not question the impartiality of the arbitrator in adjudicating the present dispute. Because, my lord, I showed from the first minutes that it was all stated to be prior appointments. The application is definitely beyond the period of 15 days prescribed under section 13. I'll show that is not so. The claimant all along was aware of the fact that the arbitrator has appeared as a counsel. However, the claimant has never felt that there is any justifiable doubt as to the impartiality of the learned arbitrator. On the contrary, the claimant applied for extension of the mandate of the arbitrator, and in terms of section 29A, the claimant the mandate of the arbitrator extended for adjudicating the disputes between the parties. So this I showed, my lord, it is in August 2024. There is no cause which is being shown as to why the claimant would have different perception than what it had from the time when such extension was granted to the arbitrator to make and publish the award, save the continued failure on the part of the claimant to produce its witness to adduce evidence and the persistence of the arbitrator to proceed with the reference. The counsel for the claimant vociferously attempted to qualify the circumstances under entry 23 and 30 of the fifth schedule as applicable to the present case. However, the arbitrator is not an affiliate of any law firm and has never acted on behalf of any entity and or the client. The same is well known to the counsel of the claimant as well as their advocate of record. It is unfortunate that the same has been brought up at this juncture by the claimant, and the same is in bad taste. The arbitrator is in his entire career has never accepted any wakalatnama and or on behalf of any entity or client. The restriction under the fifth schedule, entry number 21, relates to only actions in the past. Entry 21 does not contemplate actions in future, and hence, even by applying such tests, the case of the claimant does not qualify under entry 21 of the fifth schedule. Insofar as section 12.1 and 12.2 is concerned, the arbitrator does not have any interest in either of the parties to the present reference. Thus, the application fails on grounds specified therein as well. I'm little shocked here, my lord, if I am appearing for a party, post, my lord, an appointment as a judge, and I won't have, my lord, interest against that party is something unusual. Professionally, that's not possible, my lord. The real cause, as the arbitrator feels, what has necessitated the present application is because the arbitrator has been seeking to expedite the present reference, and however the claimant's counsel has not been having his way all the times in present reference. The attempt on the part of the tribunal the tribunal has been continuously asking the claimant to produce its witness. The claimant has been delaying the same on the pretext of ill health of the witness. It is unnatural that the claimant, being a body corporate, has only one available person to adduce evidence. No documents have been produced by the claimant to substantiate the ill health plea of the witness. The arbitrator till date has not received any fees for the present reference since its inception. Neither has the arbitrator requested for any such remuneration in terms of the sixth schedule for either of the parties. However, the arbitrator takes pride for being appointed as an arbitrator to adjudicate this dispute by the Honorable Court, and hence it is discharging his functions as an arbitrator. The application is grossly misconceived, inasmuch as the application has been filed well beyond 15 days from the knowledge of the claimant. Such engagement as counsel has never been objected to by the claimant, and the claimant has waived its right, if any, under Section 4 of the Arbitration and Conciliation Act 1996. The claimant, despite being granted several opportunities to file his affidavit, has failed and neglected. The arbitrator has in fact indicated the claim that in the event the same is not filed within the stipulated period, the arbitrator is minded to close the opportunity to adduce evidence, and thereafter, my lord, it has been rejected. Now, my lord, I do not have any personal stand against the arbitrator, my lord. He is a fellow member of the bar, but my lord kindly sees the law that does not permit, my lord, him to proceed with the arbitration. Firstly, my lord, kindly sees, he says that, my lord, on the first sitting, he was appointed in the past. That's, my lord, something which is acceptable. Now, my lord, when somebody is appointed during the proceedings, kindly take section 12, my lord. The section mandates that, my lord, the disclosure has to come from the arbitrator. Parties are not required, my lord, to ask for a disclosure. My lord, kindly take section 12 once of the Arbitration Act. Lordship has taken, my lord, kindly sees, my lord. Grounds for challenge. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances, 1A, such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or any kind, which is likely to give rise to justifiable doubts as to his independence or impartiality. This is the first sitting. There is no doubt, no quarrel, my lord, that he made a disclosure then. This, my lord, he has done. Now, my lord, kindly comes to the explanation 1 and 2, and then, my lord, subsection 2. The grounds stated in fifth schedule shall guide in determining whether the circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. And 2, my lord, the disclosure shall be made by such person in form specified in the sixth schedule. Now comes, my lord, the section when proceedings are on and the, my lord, disclosure to be made by the arbitrator. An arbitrator from the time of his appointment and throughout the arbitral proceedings shall without delay disclose to the parties in writing any circumstances referred to in subsection 1, that is any connection with the parties or against them, unless they have already been informed by them to him. Here, my lord, admittedly, once I approached him, he made the disclosure. He never disclosed that, my lord, post the proceedings being, my lord, initiated before him, and, my lord, the mandate was extended, that he has taken up, my lord, 4 matters against, my lord, the claimant itself. And this, my lord, saying that I have to approach is wrong, because the language is clear, my lord. The arbitrator has to disclose. I don't need to, my lord. He has to disclose throughout the proceeding till the award is passed. Now, my lord, kindly takes 13, because he now complains of there is a delay. So, and, my lord, 3 kindly sees, if I find out, then, my lord, an arbitrator may be challenged only if circumstances exist that give rise to justifiable doubts as to his independence or impartiality. My lord, naturally, if a client comes to know that he is appearing against him during the pendency in 4 matters in court, obviously, my lord, no client would be comfortable to continue with, my lord, before the same judge. But that is why they say the same judge cannot be hearing the same his cause only in which he has passed an order. And, my lord, kindly sees 4. A party may challenge an arbitrator appointed by him or in whose appointment he has participated only for the reasons of which he becomes aware after the appointment has been made. So even if I, my lord, filed a section 11 and he's been appointed in my section 11, if I come to know of circumstances which give rise to, my lord, his independence or impartiality, then, my lord, I have a right to come and challenge his appointment. Now, my lord, apropos this, kindly takes 13, where he complains of delay. That also doesn't stand. Kindly sees, my lord. Subject to subsection 4, the parties are free to agree on a procedure for challenging an arbitrator. Failing any agreement referred to in subsection 1, a party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal, I can challenge, this is first part, after he, my lord, enters the reference, or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of the reasons for the challenge to the arbitral tribunal. So, my lord, I do not fall under the first part of 15 days. I fall, my lord, under the second part. Under the second part, my lord, whereby immediately upon his disclosure, the disclosure is made, my lord, on 8th of February 2025. That's at page 22. And my lord, we have filed on 13th of February 2025. Lordship will see the honored affirmation at page 33. So even if I go by 15 days, I am covered. Even although 15 days doesn't, my lord, go, my lord, as far as I am concerned, because, my lord, I have to file it the moment I am aware of such circumstances. So, my lord, kindly see 22. Page 22 is 8th of February 2025. That's his disclosure. And, my lord, my affirmation of the application under 12 and 13 is at page 33. That's, my lord, on 13th of February 2025. So that finding also of a delay is also, my lord, incorrect apropos the law, my lord, as the Arbitration Act is concerned of the arbitrator. Now, my lord, apropos this, I come before my lord because, my lord, kindly sees section 14 now, as my learned friend has raised, my lord, a point of maintainability. My lord, kindly sees 14. The mandate of an arbitrator shall terminate and he shall be substituted by another arbitrator if he becomes de jure or de facto. So, my lord, under the law, if he is, my lord, not entitled to continue as an arbitrator, there is no question that I have to come before my lord under section 14. And de facto also, because, my lord, under the facts also disclosed by the arbitrator, he falls under, squarely falls under the, my lord, incapabilities under 12 and 13. So, my lord, he becomes de jure or de facto unable to perform his functions, or for other reasons fails to act without undue delay. Now, my lord, I fall under, my lord, the first part, where, my lord, by the statute itself, he is unable to perform his, my lord, functions. Now, my lord, kindly sees, my lord, B is he withdraws from his office or the parties agree to the termination, which he has not. If a controversy remains concerning any of the grounds referred to in clause A of subsection 1, a party, unless otherwise agreed by the parties, apply to the court to decide the termination of the mandate. And that's exactly what I have done, my lord, before my lord, by way of this application. Since, my lord, they did not agree, so I have to come before my lord by way of an application under section 14. Now, my lord, kindly sees, if under this section or subsection 3 of section 13, an arbitrator withdraws from his office or party agrees to the termination of the mandate of an arbitrator, it shall not apply acceptance of the validity of any ground referred to in this section or subsection 3 of 12. This, my lord, does not apply to us. And 15, my lord, is that for a substitution, that, my lord, if there is a, my lord, termination which is passed by my lord, kindly sees 15.1. In addition to the circumstances referred to in subsection 13 or 14, the mandate of an arbitrator shall terminate where he withdraws from office or any reason, or by or pursuant to agreement of the parties. Now, my lord, if by the reason of the order passed by my lord, he has to withdraw, then, my lord, or recuse, or his mandate is terminated, then lordship will has to replace him with a fresh arbitrator. That is the, my lord, provisions of 14 and 15. And, my lord, this does not say at all that, my lord, I have to come under the 5th schedule, or, my lord, the 6th schedule, or the 7th schedule. Now, my lord, kindly sees the 5th schedule, which the arbitrator thirdly complains of does not
Mr.
qualify.
Banerjee, let them file the reply. We'll decide.
They filed a reply, my
They
lord.
filed a reply.
So they have not. You want to file a reply?
I'm
Very
sure
good.
they want.
File a written
Oh, I
objection
thought that.
there.
My lord, only one
And
thing.
then we could have decided.
Only one thing, my lord, is that, my lord, on 26th, which my learned friend will also agree, is the arbitration proceeding, and the arbitrator made it very clear that if there is no order of the court, then he'll proceed with the arbitration. So, my lord, kindly, yes, kindly, my lord, have it, my lord, that on 26th he should not proceed. By the next date, lordship is keeping, my lord, I can.
13, section 13 is a self-contained code on a challenge proceeding. Well, kindly takes it. It's a.
We'll decide it, sir. You argue the matter and we'll.
Yes, my lord.
Yes, my lord.
So, on
The order has
26th, he should not proceed, my lord.
Order has been passed, which is not appealable under the court.
We not filed an appeal.
Under the act, the order is not appealable.
I have come under freshly under
He has
1450.
not challenged the order passed under that 14th. What is the date of the order?
Yes.
I have not challenged that order.
Not challenging.
Kindly takes what happens when he decides. That is clearly mentioned in the act. Now, kindly take section 13.
Section
13 of the act.
Today is what?
Today is, my lord, 25th. So tomorrow it is there, my lord. He will proceed. Kindly, my lord, keeps it, my lord, any day.
Is arbitration. He is the
No, yes, my lord. So I don't want it, my lord. So kindly, my lord,
one.
stays it till such time that, my
13,
lord, lordship decide.
Subsection 4.
Sorry, 20?
Section 13, subsection 4.
Yes.
If a challenge under any procedure agreed upon by the parties or under the procedure under subsection 2, they have filed that application, is not successful, the arbitral tribunal shall continue the arbitral proceedings.
Yes.
And shall make an arbitral award. Now, my lord, kindly comes to subsection 5, where an arbitral award is made under subsection 4, the party challenging the arbitrator may make an application for setting aside such an arbitral award in accordance with section 34. So, legislature is clear. If you have any justifiable doubts, challenge before the arbitrator. Arbitrator will decide. If he decides against you, he will proceed with the arbitration.
Yes, my lord. I have not come under 13.
No, wait a minute, Mr.
I have
Banerjee.
come under 14 and 15 before, my lord.
Right, you have come under 14 and 15, I understand, but what precluded you or stopped you from challenging it? What are the dates? The dates are very relevant here.
Yes,
Yes, my lord.
They were represented in those proceedings. They were aware of those proceedings.
My lord, I am.
You have taken the recourse of filing a 13 application.
Yes, my lord.
And order has already been passed.
Yes.
Right? And then subsequently filing this 14 and 15 for the same.
I cannot, my lord, I cannot come straight away for 14 and 15 because, my lord, under section 13.
What precludes you?
It's not a question of precluding, my lord. My lord, it is natural that, my lord, I will go before the arbitrator since, my lord, is appearing in matters. It is natural, my lord, in such circumstances, if I come before a court and say lordship has appeared for a client, lordship usually recluses.
Mandate?
Yes,
I have.
You could have challenged the mandate.
I have challenged. That's exactly what I have done under 12 and 13. Now, my lord, in 13, he passes an order. I have no issues. He's continuing with the arbitration. I have not stopped the arbitration. I came under 14 saying that, my lord, de jure de facto, he cannot continue any further. De jure de facto, my lord. He cannot continue any further, my lord, with the arbitration proceedings because, my lord, I'll show a Supreme Court of latest judgment, my lord, of the Supreme Court saying that in such cases, court should not look into anything because this is unheard of that an arbitrator during the course of the proceeding takes a, my lord, matter against, my lord, the claimant and proceeds against him as a counsel. This is unheard of, my lord.
Fully participated.
Similar agreements. Fully participating, I have not done. I have, the moment I came to know, I have asked him to disclose.
All right, we'll have it after lunch.
But only thing, my lord, kindly keeps it, my lord. After lunch, my lord, I have few matters fixed, my lord, in the courts, my lord. I thought that.
I can't stay the proceedings. No.
My lord, at least if he gives a reply, otherwise I'm ready to argue the matter, my lord.
On law, my lord can decide this.
Yes, on law, my lord.
Yes,
Lordship has a matter fixed at 2 p.m. also.
We'll take this first and then we'll take.
Very well, my lord.
We'll take this matter and then we'll decide.
But can we come back, my lord, at 3? My lord, can I come back at 3 p.m.?
3:30.
But this won't take much of a time, my lord. I don't think so. 3 o'clock.
If
See, because there are matters fixed at 2, which I, my lord, before the division bench, I had fixed it taking leave. So, my lord, can I come back at 3 o'clock, my lord?
Try your luck, because in between then I'm not going to take this back.
No, no, not in between. At 3 o'clock, I'm saying, my lord. I'll come back at 3 so that my lord can, my lord, take the list, my lord. I'll come back at 3 o'clock, my lord.
You can try your luck at 3.
Not trying my luck, my lord. If lordship says, I'll. Otherwise,
If I start that 34, then I don't know how much time they are going to take.
oh, the one that lordship has fixed at 2 p.m. Oh, but I am
That's again an argument.
I understand, my lord.
That's my only difficulty.
Or কালকে সকালেও আসতে পারি আমরা।
When you come
Or come back tomorrow morning. It's in the evening tomorrow, my lord. The arbitration is in evening.
tomorrow,
Yes, I can come back tomorrow at 10:30, my lord.
tomorrow,
Yes, at 10:30 I'll come back.
I'm not recording anything. We'll see.
No, no, my lord, because my lord, obviously tomorrow in the evening the arbitration is. We can always come back tomorrow.
Not today, tomorrow. Keep it as in the morning. First 5 matters were done.
Yes, ma'am.
We'll finish. You are appearing?
Appearing for judgment letter, number 1.
My lord, I appear on behalf of the award holder.
मेरे पीछे बोलिए
मैं
इस अदालत में आके
इस अदालत में आके
जो कुछ बोलूंगा
सच बोलूंगा सिवाय झूठ नहीं बोलूंगा,
नहीं छुपाऊंगा।
कुछ नहीं छुपाएंगे।
आपका नाम बताइए।
परिमल दे।
पिताजी का नाम
श्री श्यामल दे।
बांग्ला बोले सर। श्यामल दे।
আমার 52 প্লাস। ব্যবসা করি, এখন টোটালি বেকার। কিন্তু
नाउ अनएम्प्लॉयड। एड्रेस
13 বারোয়ারি তলা রোড, কলকাতা 10।
बारोवारी
তলা রোড, কলকাতা 10।
तला रोड কলকাতা 10। তাকে আপনার উকিল দ্বারা একটা সম্পত্তির হলফনামা
कौन सा ये वाला?
দিতে হবে। সেটা জমা দেওয়ার যে ডেট থাকবে একটা ডেটে আপনাকে আসতে হবে, না আসলে পরে আবার অ্যারেস্ট করে নিয়ে আসা। বাকিটা আপনাকে উকিল বুঝে দেবে, ঠিক আছে?
সম্পত্তি বলতে আমার কি সম্পত্তি নেই তো?
যা আছে
আচ্ছা
না থাকলে নেই,
আচ্ছা।
তা আপনাকে উকিল
Take down. आपको पता है ना क्यों लाया गया है? हिंदी समझ में आता है ना?
हाँ सर।
कब पैसे देंगे?
सर एक्चुअली वो लोग तो गाड़ी तो ले लिया, तो मेरा तो कोई काम धाम नहीं है। गाड़ी गाड़ी जब चलता था हम तो ईएमआई तो दे रहा था, यानी 2 साल के कुछ ज्यादा हमने ईएमआई दिया। गाड़ी लेने का टाइम में 2 लाख रुपया डाउन भी दिया। उसके बाद गाड़ी वो लोग बेच दिया, गाड़ी बेचा 13 लाख में। फिर भी लोगों को अभी तक पूछा ही नहीं है। गाड़ी हमने खरीदा है
My
15
lord, we
लाख
have sold the asset as per the direction of the arbitral tribunal. The asset has been sold at the tune of 12 lakh rupees. The remaining amount,
How much is left?
the how much is this?
How much is the balance?
Balance amount was at the tune of 6 lakh rupees. With interest, it was around 10 lakh rupees.
Still, which is due?
Still, which is due.
Why don't you settle it?
My lord, we are willing to settle it. They can come up with an offer.
Approach the company lordship,
Approach them,
the
you know.
award holder. We will approach for settlement. The direction may be passed to supply me the copy of the proceedings of sale, because he does not have anything.
Give the details of the sale.
Details of the sale proceeding and the copy of the affidavit along with the
Let them reach us with the proposal. We will give a copy to them.
No, copy with the application, copy of the application, so that I can file the wakalat.
Application has to be given to her.
Application has been served.
We don't have now.
I'll serve another copy.
I'm requesting.
Take it down.
I'll serve another copy.
In terms of the order dated 25th September 2025, in terms of the warrant of arrest issued by order dated 25th September 2025, the award dated number 1, Parimal Day, has been brought to the court. Full stop. Oath has been administered. Full stop. Learned counsel for the award debtor on instruction states that the award debtor shall file his affidavit of asset and shall remain present in the court.
My lord, may there be a direction to file the affidavit of asset on behalf of the judgment debtor number 2 as well, because she's a
lady.
She's a wife of judgment debtor number 1.
The learned counsel for the award debtor, you appear for 2 also.
I'll appear.
Award debtor number
No
2
issue.
undertakes to file the affidavit of asset on behalf of the award debtor number 2 and states that both the award debtor 1 and 2 shall remain present before the court as and when required for examination.
Grateful, Lordship. My liberty may be granted to file the wakalatnama as well.
The respondent, counsel for the respondent is praised and is granted liberty to file her wakalatnama within a period of 2 weeks
1 and 2 both, Lordship.
on behalf of respondent number 1 and 2. Warrant of arrest is discharged. Formatted जो order है.
Grateful, Lordship.
Grateful. List on after 4 weeks.
Grateful, Lordship.
I appear for the judgment debtor, my lord.
My lord, I appear on behalf of the award holder.
मैं
इस अदालत में आकर
जो कुछ बोलूंगा सच बोलूंगा सच के सिवाय झूठ नहीं बोलूंगा कुछ नहीं छुपाऊंगा मैं वीरेंद्र कुमार पटेल और जी कुमार पटेल श्री इंद्रदेव पटेल पटेल 45
क्या करते हैं
डॉक्टर
एड्रेस
1450 ऑब्लिक 782 अपोजिट हनुमान मंदिर चंदन कॉलोनी गंगानगर गढ़ा जबलपुर गढ़ा
जबलपुर
जी
मध्य प्रदेश
जी
कितना
जी
पिन कोड
482 003
के एडवोकेट के द्वारा यहाँ पर एक एफिडेविट ऑफ एसेट्स और एक डेट जैसा बोलेंगे उसमें आना है नहीं आएंगे तो फिर आपको अरेस्ट करके लाए
जी
ठीक है
जी
क्या नाम है आपका?
जी सर वीरेंद्र कुमार पटेल
पैसे कब देंगे?
सर दे दूंगा जल्दी
एफिडेविट एसेट फाइल करिए अपना
जी
और जल्दी दीजिए.
जी
Lord, one more thing, my lord. We have found instruction. I'm submitting that we have not received a copy of the execution application.
My lord, it has been served. We have filed the affidavit
My
of
lord,
service
may a
as
copy
well.
be handed over to me?
We'll serve another copy.
My lord, lordship will also keep the point of executability of the award open.
Why?
My lord, I don't know whether who has the arbitrator, my lord, because he has not received what he has submitted, that he has not participated in any of the arbitration proceedings. My lord,
I don't need to do it. He has just been produced on warrant. Give a copy of that. File your affidavit of asset.
yes, we will file that.
Details.
File your affidavit of asset file करिए.
जी.
After 4 weeks. उसमें वो you want to file your वकालतनामा, right?
Wakalatnama file करेছি? No. We will file the wakalat. My advocate.
Within 2 weeks, liberty is granted to file the वकालतनामा within 2 weeks.
Well, we'll file it within the course of that day. But that's it.
Yes.
Back to arguing jurisdiction 2-1 again before your lordship. But I had started on the last occasion, my lord. If my lord is pleased to take a look at
Yes.
Lord, volume 5,
where the award is there in appended as the last document, my lord. That would be, my lord, after page 669.
Yes.
Has your lordship got it, my lord? The award, man.
There's
Yes.
the 15 July, right?
Yes.
Yes.
My lord, 2-3 things your lordship would kindly take a note of. Firstly, my lord, this is on a stamp paper of rupees 150. 100 in this page, 50 on the next page. Second, this stamp paper is of West Bengal. Third, this is by the Indian Chamber of Council of Arbitration.
Yes.
Fourth, my lord, the award is been published in Kolkata.
Yes.
So, my lord, whatever it is, my lord, a substantial and material part of the cause of action has arisen in Kolkata, which gives me the jurisdiction under 2(1)(e), my lord, to file the proceeding here. Now, the argument of my learned friend that, my lord, the contract has a specific clause which bars it. Kindly takes a look at that clause. Kindly takes a look at volume 1. Page 32. It starts from
Gopal.
I'm sorry, volume 1.
Volume 5. Yes.
Now the contract starts from, my lord, page 29.
Yes.
Now the relevant portion your lordship would find the clause is clause 14 at page 32. May I place it, my lord? Any dispute, differences, or disagreement between the parties arising under or in relation to this contract, including but not limited to any dispute, difference, or disagreement as to the meaning of the terms of this contract, or any failure to agree on any matter required to be agreed upon under this contract, shall be possible to be resolved by negotiation and mutual agreement by the parties within 30 days. Should no agreement be reached, then the dispute shall be finally settled by arbitration upon the request of either party thereto, in accordance with the rules and conciliation and arbitration of the Indian Chamber of Commerce of 3 arbitrators in English language and in accordance with the said rule. The result of such arbitration shall be final and binding on the parties and for all purpose. Then the next line, the venue of the arbitration shall be at Bhubaneswar. So relying on this, there is no jurisdiction clause in this. Relying on this venue clause, it has been submitted that since the venue is at Bhubaneswar, no seat is specifically mentioned. So this venue should be taken to be the seat, and so the courts of Bhubaneswar would have the jurisdiction. Right. My lord, firstly, my lord, I oppose that submission on the point that, my lord, unless there is an exclusive jurisdiction clause, the natural jurisdiction of a court cannot be ousted. But this is, my lord, the age-old principle that if cause of action arises in 2 courts and the parties have agreed that only one court can be foisted with the jurisdiction, parties by agreement, the other court, which also has the jurisdiction, cannot be, my lord, excluded. That's the first principle. Second is, my lord, will kindly permit me to hand up the rules of, my lord, the rules of arbitration of Indian Chamber of Commerce, my lord, arbitration. Kindly takes a look at Rule 30. Both sides were given one each. I don't know. I also don't know. But kindly takes a look at Rule 30, my lord.
Yes.
My lord, will kindly see here the specific clause is that it would be in Kolkata.
Not really.
My lord,
the place of venue of arbitration shall be Calcutta, India. However, the council having regard to the convenience of the arbitrator.
For the convenience. So, my lord, what I submit is, my lord, this is the seat. This is the designated seat. For convenience, the venue may shift. This is my argument, my lord, which has shifted also. But, my lord, my contention is that if it is an ICC arbitration, then ICC rules prescribe that it would be in Kolkata. But the parties may, for convenience, hold sittings elsewhere. So, my lord, the language perhaps would, my lord, mean that this is the designated seat for the ICC arbitration, and parties, for convenience, may, my lord, have the venue shifted to any other location. But what happened in our case is, my lord, the clause mentioned Bhubaneswar. Now, none of the parties wanted at Bhubaneswar. So, my lord, what we agreed is alternate sittings would be held in Delhi and Calcutta. So, this is what had happened, but that is qua the venue. But perhaps, my lord, the language of this, and because it is an ICC arbitration, because of this clause, this would possibly be the seat. This would possibly be the seat. Well, it's not. There is no section 11 in this matter. There was never any. They wrote to the ICC, Kolkata. ICC appointed an arbitrator from their panel of arbitrators. Now, my lord, apart from the fact that, my lord, the agreement does not provide for, apart from the fact that the agreement does not mention any jurisdiction clause, but otherwise, my lord, if I can satisfy your lordship, that, my lord, this court also has the jurisdiction. My lord, I need not put my game to such a high level that this court only has the jurisdiction. But only thing I need to satisfy, in my humble understanding, subject to my lord testing it, of course, is that if I can satisfy this court has some jurisdiction, some cause of action arisen here, then 2(1)(c), my lord, 2(1)(e), my lord, tests are met. My lord, for that, my lord, I have placed, my lord, that this ICC arbitration is here, my lord. The seat, or even if your lordship does not, my lord, accept my arguments, it's that it's a seat, even then this is there. The venue, I'm sorry, the award was passed here. It was communicated to my clients here. So, my lord, there is some part of cause of action which has arisen here. So, my lord, if there is no exclusion to, I'm sorry, if there is no specific designation of any court with the jurisdiction, then, my lord, a court which otherwise has the jurisdiction cannot be ousted. This is my sum and substance of the argument with reference to, my lord, their point of jurisdiction. Now, my lord, just to give your lordship, my lord, a nutshell of why I had to challenge this interim award. My lord, statement of claim was filed by them. We filed a statement of defense. They filed a rejoinder. But they filed an application under section 31(6) for an interim award. But we realized that in our statement of defense, there was some mistake with regard to figures. Well, we had filed an application for amendment of the statement of defense. Now, we had pressed for the amendment application to be heard first, because, my lord, that is perhaps, my lord, that is the law, that when an amendment application is there, that has to be heard first, allowed, disallowed, whichever way, but that has to be heard first. Thereafter, the other applications would be heard. That was negated by the tribunal. What the tribunal did was directed exchange of affidavits in both the applications, my amendment and his, my lord, 31(6), and heard both the applications together. Now, while dealing with that, the learned arbitrator passes one interim award, which is the one I had placed. In that interim award, the learned arbitrator, my lord, adjudicates on merits my amendment, and why, my lord, he feels that this is deholds the contract. So, my lord, this is in the nature of, my lord, deciding the merits of an arbitration of an amendment application while considering an amendment application on which, my lord, in my humble understanding, subject to my lord testing it, of course, the law is settled that, my lord, merits of an amendment cannot be considered while deciding an amendment application. But the learned arbitrator departs from such settled position and decides on the merits of my amendments, and, my lord, disallows that. And before doing that, the learned arbitrator considers their 31(6) application and allows that. Allowing their 31(6), which, my lord, is really, my lord, my amendment is really linked to those figures which they have allowed in the 31(6). So, my lord, I had wanted correction of certain figures,
Right.
on the basis of which they filed the 31(6). So, my lord, in my humble understanding, but the amendment application ought to have been considered first. Now, kindly takes a look at the award first. Volume 5, my lord.
Yes.
Has your lordship got it, my lord?
Yes.
Kindly sees the opening sentence. This is to consider an application under section 31(6) of the Arbitration Conciliation Act. It is stated that applicant such and such, my lord, I am not troubling your lordship with this. But so, my lord, the arbitrator considers an application under 31(6) first. Now, the arbitrator holds that there should be an interim award. My lord, now kindly comes to my lord, page. My lord, I kindly permit me to refer to by the internal page because there is no pagination. Kindly takes a look at the page 27, internal page 27.
Yes.
But here, I am really sorry, my lord, would your lordship kindly keep the first volume beside? Because I need to show from the contract to, my lord.
Right here.
Yes. Kindly takes a look at the contract once, my lord.
Yes.
Page 30. Well, this is one of the moot issues in the, my lord, amendment, and also, my lord, my challenge here. But this is the specifications of the coal. There's a table.
Yes.
This is the specification of the coal which, my lord, had to be supplied to, my lord, the respondent herein, the claimant in the arbitration. My lord, kindly takes a look at the first, my lord, row, total moisture. Your lordship would find typical specs is 9.9. And, my lord, the penalty is excess moisture above typical specs be deducted from RR weight. Your lordship would find the next one is ash. In ash, that is the only component, my lord, that had a tolerance, which is 0.5. And, my lord, will find rejection is, my lord, 11.5. Above 11.5, there is a rejection.
Right.
In the penalty, it is mentioned that if results exceed tolerance, then rupees such and such per metric ton for each 1% above typical specs up to rejection fraction pro rata. My lord, what the issue was in the amendment application, my lord, the respondent had indicated that, my lord, if the moisture content is, the ash content is more than 10.5%, then the pro rata had to be calculated from 10.5 and not 10, because otherwise it would render the tolerance osseous. What they say is that the contract stipulates that 10 is the typical specs, 0.5 is the tolerance, and the penalty says once it exceeds tolerance, it would fall back to the typical specs. So this was the moot issue of difference between the two parties. So, my lord, all I want to say today is that, my lord, it may be a correct interpretation. It may not be a correct interpretation at the end of, my lord, the evidence. But to, my lord, prevent me from leading any evidence on this, or, my lord, running this case, my lord, this would possibly be against the principles of, my lord, and, my lord, Order 6, Rule 17. Because, my lord, if your lordship kindly visualizes one situation, I could have taken this defense otherwise in my statement of defense as well. Then nobody could have stopped me, barring saying that that is incorrect. That is dehors the contract. That is dehors law, whatever. That right they still have. So, my lord, stopping me, preventing me at this stage, while my amendment application is being adjudicated, and my lord, giving a detailed finding on how this amendment would be divorce the contract is possibly what is not permissible in law in case of an amendment. And also one thing, this is not an amendment of a plaint. This is an amendment of a written statement where I can take mutually destructive pleas, I can take mutually alternative pleas, unlike a plaint. So one of the standards for allowing a plaint amendment and the standards for allowing an amendment of a written statement are not completely different. So this is one side of my argument. The second side of my argument is how would, if I may ask this question to myself, how would the claimant respondent herein be prejudiced by the amendment being allowed? He can still contend that yes, this is divorce the contract. He can still say in his defense and also prove by evidence, because his witness was not in the box at that point of time. The evidence had not started. So he had the ample opportunity to disprove my statements. So it's not that he had admitted all my other statements. He had disputed several other statements. This would have been a further statement which he would have disputed. But what the arbitrator does is, here's my amendment application, negates it, holding detailed finding as to how that is bad. Third, possibly, my lord, the award also militates against the principle of section 28(3) of the Arbitration Conciliation Act. If my lord is pleased to take a look at that provision once, your lordship has seen it umpteen number of times, but just for my satisfaction, your lordship. Kindly see 28 subsection 3, my lord, section 20 subsection 3. While deciding and making an award, the arbitral tribunal shall, in all cases, then kindly marks this, taking into account the terms of the contract and trade usages applicable to the transaction. So, my lord, if that amendment would have been permitted, I could have had the opportunity to, my lord, lead evidence on the contract also, as well as the trade usages also. But whether that would have been tenable at the end of the day is a separate issue. But my lord, I would have had the chance to, my lord, impress upon the tribunal that the trade usages permit this document to be interpreted as such, which I was specifically disentitled at that stage. So, my lord, this is why, my lord, this is a final adjudication on merits, and I would be precluded from arguing this point ever in the arbitration. This is with so far as the amendment is concerned, because a point has been taken by my learned friend that from a rejection of an amendment application, a section 34 is not maintainable. But I say that an interim award has no form or manner as such. Section 31 language is, if there is a final adjudication on any aspect, that becomes an interim award and is challenged, or the challenge is open under section 34. So, here your lordship would find, and I shall trouble your lordship with certain findings, that I would now be precluded from making any submission on this ever, without my evidence even having gone into at that stage. Now, my lord, what they have also done is, my lord, they have also argued is that in one of the annexures to my statement of defense, in an email, we have mentioned certain amounts. So we are wanting to resile from those admissions. So the amendment could not have been permitted. This is one of the other planks of argument. To that, my lord, I have twofold submissions. A, amendments can be explained. Admissions can be explained. So what I was attempting to do is explain the admissions which is there. And B, this would be prejudging the issue at the amendment stage. But if I could have dealt with that in my statement of defense, that missed all of our attention. So, if that be so, in the statement of defense I could have explained, then that they could have had an opportunity to deal with that in the rejoinder, in the arbitration through evidence. But kindly sees that document once. In fact, I'll deal with that document later. Kindly comes back to the award once.
You were asking me to read something from the award.
Yes. Kindly takes a look at page 27, internal page 27.
Yes.
The paragraph starting with according to the aforementioned admissions. Has the lordship got it, Mal? Page 27.
Yes.
According to the aforementioned admissions, the learned advocate for the claimant argued on the basis that the respondent's specific admission made in the statement of defense, claimant is entitled to a principal amount of rupees such and such. The respondent, also not denying the entire claim of the principal amount as stated in the claimant, is contending that there is some clerical error. Therefore, the claimant will get less than the amount claimed. They have filed their opposition to the application for interim award and has also filed an application for amendment of the statement of defense. It is stated in paragraph 4 of the statement of the amendment application that the amendment sought to be proposed by the respondent as mentioned in paragraph 3M occurred owing to a clerical error on the part of the advocates appearing on behalf of the respondent. It would be evident that an amount of rupees 24,205.89 that the respondent seeks to replace the amount of rupees 131,311.59 in paragraph 3 appearing as such and such. According to the respondent, correct figure has been calculated in the form of chart in annexure A. The respondents further contend that in paragraph 12 of the SOD, total amount the respondent agreed to pay to the claimant in the form of penalty has stood altered to the earlier mistake, and therefore rupees 20,96,000 odd should be recorded in place instead of rupees 22 lakhs odd, which is not correct. They also state in page 2 and 3 of the railway receipt number such and such was seen omitted from being annexed to the SOD. Therefore, the entire document should be allowed to be annexed. Mr. such and such advocate for the respondent submits that the result of ash percent assessed is 10.613, which the respondent not disputing. He submits clause 4 of the contract specifically stipulates permissible ash percentage and according to contracts, permissible specs 10.0, tolerance 10.5 and rejection value more than 11.5 and penalty fixation mandate stipulate if results exceed tolerance then such and such should be interpreted following way for calculation of penalty. Ash 10.613 less typical specs plus tolerance is equal to 0.113 should be taken for calculation of penalty. If calculation is made in this way, then the calculation of penalty for excess ash content and moisture content would come to same value as calculated in annexure A. And that is why they prayed for amendment on their calculation made in annexure A to SOD. According to him, if 0.5% tolerance is not added with typical specs, then tolerance part would be otious. He submitted amendment should be allowed first without any consideration of merits and it would be adjudicated at the time of final trial. He cited some judgments in support of his contention. But then kindly turns to the next page, the next paragraph. The entire argument of Mr. Such and Such is based on interpretation of penalty clause 4.0 of both contracts. In this case, a percentage of ash content as assessed by the assessor engaged by the claimant as per contract is 10.613, which is not disputed by the respondent. Both the parties admit RR quantity of such and such. Now only question arises whether calculation for penalty should be as percentage less, typical specs plus tolerance or typical specs only. In case Mr. Gupta's argument interpreting clause 4.0 is accepted, then amendment sought by the respondent should be allowed and the principal amount of claim should be reduced as stated by the respondent. In the event the calculation is given by the claimant through the learned advocate Mr. Sunny, that is ash percentage less, typical specs is accepted, then the claimant's claim should be allowed and there would be no necessity to allow the respondent to amend the SOD or correct the figures as they have specifically stated in paragraph such and such of SOD, which was affirmed as true to their knowledge. Now let me consider what the penalty clause actually speaks. Then the entire finding is given on what the penalty clause speaks. In clause 4 of both contracts, the last part of ash percentage column clearly stipulates if results exceeds tolerance, rupees 60 per MT for each 1% above typical specs up to rejection, fraction pro rata should be calculated. In my view, this clause has two parts, imposition and assessment of penalty. It is also clear and specific that up to 10 specs, no penalty is imposed. In case of ash exceeding typical specs plus tolerance 0.5, then only imposition of penalty would arise and thereafter calculation of penalty would be made as stipulated. Rupees 60 per metric ton for each 1% above typical specs only up to rejection, which is more than 11.5, fraction pro rata only, which is very much clear from the reading of the penalty clause. This is the plain and simple reading of the penalty clause, which does not have any crease or curve. The clause never stipulates penalty be calculated deducting value of typical specs and tolerance. Therefore, for calculation of penalty, only typical specs should be deducted from ash content, not otherwise as suggested by Mr. Gupta. Then accordingly, calculation should be such and such. So, this final finding is given on the clause. Preventing my right to set up this defense, my right to give evidence on the trade usages. It's not an issue at this stage whether I can sustain my contention or whether it should be dismissed straight away. I may sustain, I may not sustain. The evidence have to be weighed. But at this stage, especially when an amendment of a written statement, with statement of defense, is sought, where alternative and mutually destructive pleas can be taken, to prevent this at this stage is a patent illegality, which your lordship would kindly consider in a section 34 and set this aside. On this issue, may I rely on a few judgments, that the amendments of a written statement has to be liberal. Kindly takes 2007 Volume 5 Supreme Court cases, page 602. Actually, we have given will kindly have a look at paragraphs 18 to 22. No,
18 to 20.
18 to 22. Paragraph 18, my lord, will find at page 608 of the report. It is now well settled by various decisions of this court, as well as those by high courts, that the courts should be liberal in granting the prayer for amendment of pleadings unless serious injustice or irreparable loss is caused to the other side on the ground of the amendment, on the ground that the prayer for amendment was not a bona fide one. In this connection, the observation of the Privy Council, it's quoted. Thereafter, 19. It is equally well settled principle that a prayer for amendment of the plaint and a prayer for amendment of... I'm sorry, madam.
Now, Swadeshi judgments.
Paragraph 19. It is equally well settled principle that a prayer for amendment of the plaint and a prayer for amendment of the written statement stand on different footings. The general principle that amendment of pleadings cannot be allowed so as to alter materially or substitute cause of action or the nature of claim applies to amendments or to plaint. It has no counterpart in the principles relating to amendment of the written statement. Therefore, addition of new grounds of defense or substituting or altering a defense or taking inconsistent pleas in the written statement should not be objectionable, while adding, altering or substituting a new case of action in the plaint may be objectionable. Such being the settled law, we must hold that in the case of amendment of written statements, the courts are more liberal in allowing an amendment than that of a plaint, and the question of prejudice would be far less in the former rather than in the latter. But then kindly also takes a look at paragraph 21. In fact, 22. Keeping these principles in mind, namely that in a case of amendment of a written statement, the courts would be more liberal in allowing than that of a plaint, as the question of prejudice would be far less in the former than in the latter, and the addition of new ground of defense or substituting or altering a defense or taking inconsistent pleas in the written statement can also be allowed. We may now proceed to consider whether the High Court. But and thereafter, it was allowed. Paragraph 26. Now that is at page 611 of the report. Therefore, it was neither a case of withdrawal of admission made in the written statement nor a case of washing out admission made by the appellant in the written statement. As noted earlier, by such amendment, the appellant had kept the admissions intact and had only added certain additional facts which need to be proved by the plaintiff and defendant numbers 2 to 8 to get shares in the suit properties alleged to have been admitted by the appellants in the written statement. Accordingly, we are of the view that the appellants are only raising an issue regarding legitimacy of the plaintiff and the defendant numbers 3 to 7 to inherit the suit properties as a. I am not troubling Lordship with that. But then the other judgment. On the proposition that merits of an amendment cannot be looked into while considering an amendment application. This is 2006, volume 4 Supreme Court cases, page 385. Kindly takes a look at paragraph 19 at page 393 of the report. 19. While considering whether an application for amendment should or should not be allowed, the court should not go into the correctness or falsity of the case in the amendment. Likewise, it should not record a finding on the merits of the amendment, and the merits of the amendment sought to be incorporated by way of amendment are not to be adjudged at the stage of allowing a prayer for amendment. This cardinal principle has not been followed by the High Court in the instant case. And the last one, my lord, on this point, on the point that amendment should be liberal, the coordinate bench judgment of this honorable court, my lord, on amendment of a statement of defense and arbitration. This is 2025 SC7. Will kindly have a look at this. Click. And this was considering an amendment to the statement of defense. I'm sorry, amendment of a pleading in an arbitration. Kindly takes paragraph 9. So the only contention of the petitioner which remains to be looked into is the factor of delay. Delay in making the prayer for amendment, it is stated. Delay in making the prayer for amendment. It is stated that the application has been made at the stage of argument, even though the claimant's case is that the amendment sought was necessary to be brought on record after the written statement or evidence was on record, and such delay in making the application for amendment leads to delay in the proceedings being completed or concluded, thus causing prejudice to the opposite party at a much later stage. An arbitration proceeding is a quasi-judicial proceeding. Though in such proceeding the provisions of Civil Procedure Code is applicable, the same is not always mandatory. Under Order 6, Rule 17 CPC, any amendment once trial has commenced becomes difficult unless certain criteria are met. Whereas Section 23(3) of the Arbitration Conciliation Act 1996 provides that an amendment or supplemental claim or defense can be done during the course of arbitration proceedings, and that includes the stage of argument and the provision not being stringent as the one under Order 6, Rule 17. The amendment permitted in the case is in accordance with the law, as the same will not change the nature and character of the claim or application and it is necessary for proper adjudication, thus not causing prejudice to the petitioner or opposite party. The arbitral tribunal permitted the amendment, though at a belated stage, but at a cost has been imposed on the claimant and the opposite party, which was a condition precedent for allowing it. And the amendment revision was dismissed. But this I was placing only for the ground that while considering an amendment to a pleading in an arbitration, the courts are much more lenient than considering a plain or written statement amendment in a suit. Yes. The other moot issue which was involved was that the contention that amendment application should be heard first, that was negated. But this is also, my lord, in my humble understanding, a settled proposition of law. My lord, could I trouble your lordship with two judgments, my lord, on this? Lord, may I place this? This is 2023 SCC Online Calcutta 1987. There's the Goralal Singh. No, no. What did I give? Yeah. And we'll kindly have a look at paragraph 14 of this report, which is, my lord, at page 4. Now, this was in fact considering a situation when a demurrer application was filed, which goes to the root of the, my lord, maintainability of the suit. In deciding the jurisdiction to try the suit in the commercial division, the trial court is required to take into consideration the averments in the plaint. In the event an application in the nature of demurrer is filed, like the present one, where the question of jurisdiction is involved, the court is required to take into consideration the proposed amendment first, and depending upon the outcome of the said application, the demurrer application is to be decided. The trial court is required to ascertain the nature of the immovable property mentioned in the agreement, if being exclusively used for trade or commerce as on the date of the agreement, and any pleading to that effect. The use of the property for trade or commerce, well, these are not really the first portion of this paragraph. But here what prejudice we suffered is when the tribunal had considered the 31(6) first on merits, going by the admissions, so-called admissions in the written statement, statement of defense, allowed their application, then considers my application for amendment and adjudicates on merit and dismisses my application. And most importantly, I shall also show from the minutes of the cross-examination also, but now questions are not being allowed in the cross-examination also. That look, there is an interim award. You cannot ask any further questions on that issue. That is decided. So, this, in my humble understanding, would possibly be against the principle. But this would be against the principles, my lord. Yes. My lord, kindly permits me to hand up the minutes of the, yes, I'm giving the minutes of the dated 1st September 2024. Kindly takes a look at, my lord, the third page. Now, this is the claimant's witness being cross-examined by me. The petitioner before your lordship, my lord, was cross-examining the claimant's witness. Kindly see question number 9. Kindly see the level to which it has gone. What, according to you, I am asking the claimant's witness, the respondent hearing. What according to you is the significance of the word tolerance? This has been disallowed. This is preposterous. My question on a word of a contract and what is his understanding of that clause is being disallowed on the ground there's an interim award. And my learned friend says it cannot be challenged. Kindly see question 10. I'm sorry, question 11. Again disallowed. Question 19, my lord. 19 is on the same issue. So, my lord, A, I would be stopped at the stage of amendment. B, I would be stopped at the stage of cross-examination. C, I would be stopped at the stage of argument. So I can never lead evidence. I can never cross-examine on any word of the contract. So, my lord, it is inconceivable that there cannot be any issue with regard to interpretation of a clause in a contract. But I could have led evidence as to how the parties understood it. I could have led evidence as to how the trade usage deals with such clauses. Nothing permitted. In fact, my lord, the arbitration clause, which is housed in the contract, permits me to do that in the arbitration. My lord, will kindly take a look at the arbitration. Your lordship need not be troubled with. I'll just read for your lordship. Any dispute, difference, or disagreement between the parties arising under or in relation to this contract, included but not limited to any dispute, difference, or disagreement as to the meaning of the terms of the contract. This is an arbitrable dispute, but I would not be. So, meaning, he may have a different meaning of the same word. That is why, my lord, this profession is, my lord, so, my lord, dynamic. Same books are there, same judgments are there, but on the same facts. But your lordships have held differently, we argue differently. So, even the interpretation of the terms of this contract is one of the arbitrable dispute, which can be referred to arbitration. But that will not be permitted. The arbitrator has returned a final finding on my amendment application that, look, the contract is clear, I will not allow amendment. And now I cannot challenge it till the arbitration. My questions will not go in. Nothing will go in. Now, coming back to the award once, my lord.
Your amendment has not been allowed.
No, their 31(6) allowed, my amendment disallowed by the same award. Now, my lord, will kindly have a look at internal page 30.
Award?
Of the award. Volume 5.
Yes.
But kindly sees the last paragraph, which starts with, since it is a mere calculation. Has your lordship got it? Since it is a mere calculation dependent upon penalty clause, which is much more clear than crystal, amendment should not be allowed on mere asking. Moreover, both sides argued on penalty clause, and the tribunal considered the submissions and found that the respondents' interpretations are different from that of the real intent and purport of the aforementioned penalty clause. There is no need to allow amendment. May I pause here for a moment? This, the finding is without any evidence being led at this stage. Only on the basis of the arbitrator's interpretation of the clause. May I read on? Therefore, the claim of the principal amount as claimed by the claimant and admitted by the respondent in paragraph such and such, as well as annexure G to the SOD is allowed in favor of the claimant. The respondent has made an advance payment of rupees such and such by account pay check on such and such, which was accepted by the claimant without prejudice to the rights and contentions, should be deducted from the principal amount, and the balance should be paid to the claimant within 2 weeks from the date of passing of the interim hour. So far as the third prayer by the respondent to include the document is concerned, the document is already on record. Now the payment of interest. Well, I'm not on that, but the interest has been awarded. But then, no, I'm sorry. Interest, there's an issue on that. Well, kindly takes a look at. Well, kindly takes a look at that annexure which I had, which my learned friend had placed, which is annexure G. We'll kindly have a look at volume 2 once. Volume 2. We will first see annexure A, which is annexed to my statement of defense. Well, it will kindly take a note of the second table at page 281. Yes. My lord kindly sees the second table, which is calculation for ash loss against the first rake of first contract. My lord will find serial number F. We have stated that ash as per contract is 10.5. Then G, ash as per IGI report is 10.613. Difference in ash is 0.11, and we have calculated the penalty as such. So, my lord, in other words, we have interpreted this already in our statement of claim that this should be only on 0.11 and not 0.611. They say that it should be 10.613 minus till 10. So 10, anything above 10 is penalty. We have already said anything above 10.5 can be a penalty. So that stand we have taken in the statement of defense already. Now kindly see is what is my pleading with respect to this particular annexure. My lord will kindly have a look at paragraph 3M of the statement of defense, which my lord will find at my lord page 238. May I place it? It's a small paragraph. M, 3M. This is one of the amendments which we sought. Insofar as the claim on account of variation with regard to the moisture content and ash content is concerned, the good supply, but kindly do not be troubled with, then kindly sees the two figures. The moisture aggregates to 20. The moisture aggregates to penalty on account of moisture aggregates to 20,72,769, and variation with regard to ash aggregates to 131,311. And my lord kindly also marks the calculations in such regard are indicated in a schedule annexed here to and marked with the letter A. So this is that annexure which I had shown. Now, my lord, your lordship would recollect from the award that we had said there was a clerical mistake. Why we had said that? Kindly now takes a look at page 281, which I had placed the table. Your lordship will not find these figures. This figure of my lord 131,311.59, your lordship will not find in the table below. Yes, there it is mentioned as 24,205.89. So we have, in support of our contention, we had annexed a chart, but the pleading of the quantum in that paragraph came down wrongly. Now, from where did this wrong occur? This is one of the annexures which my learned friend placed, page 301, that is volume 3. This is one of our emails. Yes. This is an email issued by us with regard to the refundable amount, which we had stated that on account of penalty for ash and moisture, we are liable to refund as per the contract. Now, kindly see the note below the tables. It is mentioned that in case, has your lordship got it, madam? There's a note. It is mentioned that in case the analysis report issued by buyer's inspection agency is not available within 7 days of loading of rig, then the analysis report issued by sellers appointing inspection agencies shall be final, binding on commercial. Then your lordship need not be troubled with this at this stage. Kindly see the last line. Kindly confirm the above, enabling us to proceed the refund. So this, in my humble submission, we gave them this email saying that please proceed to issue a refund on this. The tribunal negates this, but this I am placing for the on the argument of on 2-3 counts I shall be relying on. I shall be dealing with this. Firstly, on account of interest. But we had said that please confirm this amount so that we can proceed with the refund. They have not confirmed this amount. Yet, this is the amount they claim in the arbitration as my admission and wanting interest from that date. Despite us saying, you confirm, I will refund. So there is no confirmation from their end. The arbitrator holds that no, there is no valid tender of this amount. So at the interim stage, interest is awarded. At the interim stage, without permitting to lead evidence. So, since the arbitrator's finding is that you have not tendered by way of any instrument, you relying on this sentence that please confirm, which will enable us to refund. But my lord, even in cases of any judgment upon admission or anything else, but only at that application stage, your lordships have always allowed the amount admitted. But for the interest component, your lordship always, my lord, relegates to suit. Instead, my lord, the interest is awarded. That is A. B. The contract does not provide for any rate of interest. The argument is that if the contract is silent on any rate of interest, then, and there is no bar in granting interest, then the tribunal under 31(7) is empowered to grant interest. But I do not join issue with this proposition of law. But all I submit is, my lord, is this the stage, if I may ask this to myself, is this the stage of awarding interest? Wasn't they required to prove anything? Weren't we entitled to defend it? The rate, the payability of interest, anything on that count? But the arbitrator grants interest on that. But we are carrying that interest check without prejudice, which I had wanted to deposit, because it is mounting. So if your lordship is not with me at the end of the day, then it would mount. Otherwise, we can always take a refund. But if your lordship permits us to deposit this, I will. Otherwise, I leave it to your lordship.
Because there's an issue of jurisdiction. So Lordship may decide that issue.
Prejudice, without prejudice.
Because
They should.
that will be read as a that.
No, no, I
court as a-
kindly records my undertaking that this will not be a ground to say that your lordship has entertained jurisdiction. I am only then let them not pray for the interest also. Because I am ready with the check. Let them not have the cake and eat it too then. So I was ready with the check right from there. In the arbitration also we handed over the check of 72 lakhs out of the 74 admitted amount. The balance is of 2 lakhs. The interpretation, if allowed, is 2 lakhs. That is the difference. That is where the parties are really fighting. And that has ramifications later. But as of the interim award, it's only the difference of 2 lakhs. Ramifications are there later on.
It has to.
It has to, because this is only on the admitted quantum, that the 31.6. Now my entire claim, their entire claim is on the ground of excess of, this is for only for rake 1. There are 2 other rakes. 4 other rakes, I'm sorry.
So the cumulative will be
Cumulative, the effect would be much more. So I have not concluded. So now on the issue that this document at page 301 was an admission, so the amendment cannot be allowed because it would amount to withdrawal of it. Now kindly see what the admission is, if at all there is it. Here, my lord, at page 301, there are certain calculations only. But I have not found that there is any admission with regard to the interpretation of the clause. What is there is the ash content as per the report is taken as 10.613, and this email has calculations on the basis of that 0.613 and not 0.113. That's all. There is no other admission as such. Then, my lord, I'm sorry.
very interesting ring.
Sorry.
I'm saying very interesting ring. Yes.
But if your lordship kindly takes a look at this chart once, because this has been heavily relied upon by both the tribunal and my learned friend while arguing before your lordship, that there is an admission of this, so we can't resign from. But kindly see what is the admission. But here what our clients had done is calculate on the basis of that 0.613 without taking into account that tolerance. So this they want to imply that look here, you have admitted it should be on
Tolerance is what? 0.50.
0.5 is the tolerance. So their contention is that look here, you have already admitted that it should be on 613. So why are you now saying 113? That is withdrawal of admission. But here, it is not a clear admission as such, and what we were trying to do is we were attempting to explain the admissions, if at all there is one, and give the interpretation which as per us or as per the trade usage would have been. Because it is always the case that if from the it comes right from the typical specs, then the tolerance component of 0.5 would just go away. It would be rendered ocious. But be that as it may, that is really on the merits.
So they are basically only on the jurisdiction aspect, right? Like today,
No, he had also submitted on the merits also.
Merits also.
On the merits also. But that day I could not be there, so my learned juniors had taken a note. So I was.
We decide this as a preliminary issue, and then we can move on to the merits, subject to what your lordship feels.
If I'm hearing it, then
Here is lordship.
we'll continue with this.
I would be taking some more time on it.
Yes, so we'll continue. Let's continue. It's 3:30. If you don't mind.
Yes, continue.
It's a resolution, so that is what I was just only thinking.
All right, another 10 minutes. How much time will it take?
It'll take half an hour.
Well, he made a statement on the last day he will conclude in 1 hour. This is what he had said.
Kindly permits me to come back next Monday, Tuesday, any day, my lord.
Too far. All right.
Or this Friday, my lord, subject to my lord's convenience.
Not Friday.
Lordship, we give it tomorrow. We can.
No, tomorrow I'm not. No, tomorrow I'm not.
I have already kept
I'm in Supreme Court.
quite a few matters.
Fixed matter. But whenever, my lord, barring tomorrow, whenever you lord.
Tuesday?
Whenever.
Next Tuesday. Just Lordship, may just give me a second.
But only thing, my lord, kindly records that we have tendered, we have offered this check because they would be arguing on the interest, my lord.
We'll see Tuesday.
And we have been offering it for the last 4 hearings, my lord.
Tuesday. Heard listed for further hearing. Heard learned counsel for the petitioner listed for further hearing on Tuesday. थोड़ा ऊपर रखना so that we can finish it. No point.
If your Lordship may direct this to be kept up the board,
That is what. That is what he just. Your
Okay.
lord just heard.
All right.
It's going down.
Yes.
So the newer matters are coming up. That's all.
Great.
Continuity is broken.
Very grateful.
Right. I'm so grateful.
Grateful.
May I permitted to mention one matter, Your Lordship? Your Lordship. So it's for extension of interim order. Your Lordship, I had mentioned this matter yesterday. The difficulty is that the interim order is expiring on 30th, and the bank, that's a verbal intimation from Banki, they are going to take steps. If the matter is going to be listed tomorrow, Your Lordship. Grateful, Your Lordship.
May I just have back the original of the rules handed over?